of a discussion between you and your superior, Mrs. Asher? I don't need us to work through that again, but we can perhaps just provide a recap of where we closed. In summary, the WhatsApp conversations reflect the discussion we had with Mrs. Tashega on the 20th of February 2023, correct? Yes, it does. Okay. Where she raised with you a need for security in light of the disciplinary action that you intended to take, at least the suspension that you intended to take with respect to the brigadier, is that correct?
Yes, it was in respect of the suspension.
Of the suspension decision and process. What did you understand of that?
Thank you, Madam Commissioner. Indeed, my understanding was that she was reluctant because of the risk associated with the suspension itself. I didn't understand her to be reluctant in respect of the substance of the issues that pertained to the suspension, but it was the risk issue that she expressed more concern about. She did not express concern about the allegations themselves.
Thank you.
Thank you, Commissioner.
Can I just follow up on that? On page 12 in the bundle, PN2.
Yes, Commissioner.
Are you there? PN2, page 12.
Yes, I am.
You say there we need to strategize around it. Our subordinates have horror stories.
That's not me.
Is it not you? That's her?
That's Tashega, yes.
Okay. And did you know what she was referring to? Because, I mean, at this stage, all you are dealing with is the suspension of a brigadier. Why would there be concern about safety of yourself or Tashega or other people at that stage? Forget about what happens later on.
The concern about safety, if you read the commencement of the WhatsApp engagement, you know, I had expressed a view that this matter is not going to be a simple disciplinary matter, you know, because it involves a character who's outside of the institution, who is in the news, and is in the news for wrong reasons. So she also responded to say that indeed this is a very delicate issue, you know. Now, on page 12, you would see that she had firstly requested, or rather asked, whether indeed there was a risk assessment conducted as per the WhatsApp on page 11 at 11:03. So the risk assessment was a key issue to her. But then she expresses another concern at 11:07 on page 12, where she says, but I don't want people penetrating my private space. Nah. I'm too private for Lama VIP who reports issues to some of our subordinates. So what she's talking about here, in the institution, under the Specialized Services Unit of EMPD, we've got the VIP Protection Unit that then would have guards, or they call them inspectors. So everybody that is a VIP Protection Unit member is an inspector. Those inspectors are then allocated principals. Now, what Mr. Shega was raising is to say these people have tendencies of relating the private life of their principals, you know. So she says to me that I'm a private person. I don't want to be guarded by these people because my issues will be known, you know, in the institution. And that is what she's trying to deal with. And hence, her response to my 1109 message that talks about strategies is informed by that concern that she has, you know, with regards to intrusion of her private life. Yeah.
Thank you, Commissioner. Thank you, Commissioner. Mr. Ngiza, let's just make two important points here. If I could ask you to turn to page 9 of that exchange, page 9. You send a message at 3 minutes past 11, the nub of which is you confirming that despite the security challenges, you are going to send her the pre-suspension letter within the next 15 minutes. Is that right?
Yes.
Thank you. If you then just turn over the page to page 10.
Yes,
At 4 minutes past 11, Ms. Kashega asks you, have they done EMPD preliminary investigation though? And you respond immediately, yep.
Yeah.
Correct. So you respond in the affirmative to say that EMPD has at that stage where you are on the brink of issuing the pre-suspension letter, a preliminary investigation has been done.
Yes, I responded in that manner, Counsel, because you recall that I had indicated in my testimony yesterday that I had a session with Commissioner Spies and Lieutenant Colonel Erasmus, where indeed they had indicated to me the assessment that they had conducted, what I called some form of a desktop analysis of the registrations and the likes. So when she asked me that, my response was in respect of the discussion that I had with Spies and Erasmus.
Thank you. Could I then ask you to stay in the annexure bundle and just flip over the page to annexure PN3. PN3. The actual document itself will begin on page 13 of your annexure bundle.
Yes, ma'am.
Just to locate us in your witness statement, you are now at paragraph 28. And the annexure we are looking at now is PN3 that starts on page 13.
Yes.
Thank you.
I'm there.
Could you just confirm for the Commission what is the title of that document at the top of the page in bold?
The document is titled Intention to Suspend, to Suspension Letter.
So please confirm that that is the letter you were referring to in your WhatsApp communication with Ms. Kashega as
Yes, it is.
discussed. Thank you. Right. At the top left corner of the page is a date. Do you confirm that that's the 20th of February, 2023?
It is the 20th of February, 2023.
Thank you. If we have regard to the box, the details in the box just under the heading of intention to suspension letter, the suspension letter relates to which employee?
Mr. Julius Mkonazi,
Who at that time occupied what designation?
Director Specialized Services / Brigadier.
Thank you. Sorry. If we just go through some key aspects of this letter, it reads, Sir, the municipality has received allegations of serious misconduct against yourself. The allegations that have been received by the municipality relate to the following issues, and it lists 6 issues under there.
Yes, ma'am.
Mr. Ngiza, the third paragraph then, the paragraph beginning, the employer has reasonable cause to believe.
Yes.
Are you there? Thank you. Could you set out briefly for the Commission what are the reasons that motivated the issue of this intention to suspend letter?
The suspension letter started off, of course, by enumerating the issues in terms of the allegations that existed at the time against Brigadier Mkhwanazi, then the employer would this is the standard that we took from the collective agreement, that if you are going to suspend an employee, you must articulate that your suspension is in relation to these factors as per the collective agreement. So the factors that would inform the suspension would be: 1, that his presence you may jeopardize the investigations that are required to be conducted on the matters raised above or herein. 2, you may interfere with potential witnesses. 3, you may commit further acts of misconduct. Yes.
Thank you. And the paragraph right beneath.
Mr. Nzinza, what informed number 3?
Mr. Chair, that our experience is that indeed when an employee who is facing allegations of misconduct, especially allegations of misconduct of this nature, the nature of these allegations was such that they might be continuous in their very, in the conduct of the employee. The registration of the vehicles, yes, have been done, but the fact that the registration continued, he might do certain things, and indeed did do certain things that I will talk to further on, to misconduct himself further. It might happen. There are issues about dishonesty. And if indeed an employee interferes with documentation, that is a perpetuation of the dishonesty. So that's why we always have this to say, is there a potential for this employee to commit further acts of misconduct, which might be linked to the allegations themselves, or even his presence in the workplace might actually expose the institution to further acts of misconduct.
Thank you.
Thank you, Chairperson. Mr. Nziza, the final paragraph at the foot of that page invites the relevant employee to provide representations on why he or she should not be placed on precautionary suspension. Do you see that?
Yes, ma'am.
Indeed. And it invites them to provide those representations by the 22nd of February.
Yes.
Okay. Can I ask you then to flip over the page?
Yes, ma'am.
Right. Paragraph 5 at the top of the page requires the relevant employee to vacate the premises of the employer with immediate effect. Do you see that?
Yes, ma'am.
Thank you. Could I then ask you to identify the signature the first signature that appears under yours faithfully?
The first signature, Commissioners, is my signature, Olani Ngqiza, DH Employee Relations.
Followed by the signature beneath, please, belonging to?
The second signature belongs to Linda Xashega, who at that time was the acting HOD HR.
And then please identify the final signature, the third from the top on page 14.
The final signature on the document is an acknowledgement of receipt signature. The person that printed his name, J.D. Mkhwanazi, and had signed and also dated the document.
Please provide the date.
The date is the 21st of February 2023.
Thank you.
Are you reading the letter?
Yes.
Okay, maybe then let me ask my question. In the first page at 13, page 13, you've got Roman figure 3 and 4, and the allegation of gross dishonesty and possible corruption by receiving a donation in excess of the limits prescribed by council, and then the second one says allegations of violating council policy by not declaring the donation. Now, the evidence so far that we have had that relates to a donation is about printing material of about 300,000 rand by CAT VIP. Is that what this refers to, or it's a different, in your recollection? I realize it was in February 2023 when you signed this. If you can recall, was this something different to this printing material for cadets in the amount of about 300,000?
The allegation that was brought to our attention was framed in these terms, Madam Commissioner. Remember, at this point, we as the Labour Relations or Employee Relations Unit and HR per se were not seized with the actual investigation report that would have then detailed what exactly the donations were about. But on this day, when we crafted this letter, it was on the basis of the submission from the department to say that was a donation, but the nature and form of the donation was not clarified at that particular point.
And then secondly, in page 14, where you say he's required to vacate the premises, that very last paragraph there, the paragraph doesn't say to him, which we have had happened to Chief Mapieye and to Commissioner Spies. It doesn't say to him he must surrender his tools of trade, his firearm, and his computer. Does that mean he was allowed to keep this when the other two were told to hand in even their firearms? What does this mean?
Perhaps, Madam Commissioner, I can start off by indicating that what happened with Chief Mapieye and Commissioner Spies was not the standard process, you know. This is a pre-suspension letter. It's not a suspension letter. The person is not suspended, you know. This is a letter that says there is a view that the employer has taken that we should suspend you. However, we must give you an opportunity to present, you know, make representations why you should not be suspended. So at this point, you're not suspended. So there's no basis for me to say hand over things when you're not suspended, you know. And we use this paragraph on page 14. You know, we remove you indeed from the premises so that you go and actually concentrate on crafting your representations, but also to ensure that there is no malfeasance that happens in the process. Because the minute a person receives this, and again, it's experience, you know, we give an employee this, and then you hear from witnesses or from other colleagues to say that, hey, you know what, this person was doing this person was at the office looking for files and all sorts of things. So we prefer that you move away, but taking tools of trade is premature. You know, hence, I would not put that in a pre-suspension letter, because you are not suspended. The minute I take tools of trade, I have effectively now prejudged, you know, the representations that have not yet been made. It has happened in instances where a person makes representations and then it convinces us that there is no basis to suspend. You know, we can still continue the investigations once the person is at work.
And was the procedure that all suspensions must be preceded by a pre-suspension notification such as this, inviting them to make representations? Was that how it works?
It's like that. It's clause 16 of the collective agreement. Even on the disciplinary regulations for senior managers, clause 5 of the clause 6 of the regulations speaks to that. There must be an opportunity provided to the employee to make representations.
And senior managers in this case would include even chief of police and his deputies.
The chief of police, like I indicated yesterday, you have 3 categories. Senior managers would be the chief of police, HODs, and the city manager, as per the Municipal Systems Act. And then your divisional heads, like Spies, who was on the same level as I was, would then be the category that is the middle strata. And then everybody else falls under the bargaining unit of the bargaining council, and therefore they are regulated by the collective agreement.
Okay. You know. And you confirm that that pre-suspension process did not happen with Chief Mapieye and Commissioner Spies?
I was not involved, Madam Commissioner. I know about the processes, and I've listened a bit to the testimony that both gave. The process that happened is exactly as stated in the collective agreement. In the regulations for Chief of Police, provide an opportunity for representations to be made. You know, and my understanding is that that did happen.
Okay.
But what I find fault with what happened is the issue of then taking tools of trade
Yes.
before a determination is made.
Okay. Well, we've heard from Commissioner Spees yesterday that he had attended an arbitration as a witness for the employer, and then it is at that he was told you are on suspension. So it sounds like with him at least, I don't remember Chief Mapia's evidence on this issue, and we'll accept you saying it happened there. But Commissioner Spees seems to have had a completely different experience. Do you have any personal knowledge of that?
Like I say, by the time all of this was happening, I was no longer in the institution.
Okay. No, I remember
But
that.
if it happened that way, it was wrong.
Okay. Thank you. Thank you, Mrs.
Thank you, Commissioner. Mr. Ngiza, we've then wrapped up with respect to Annexure PN3. Could I ask you to stay in the Annexure bundle and then proceed to the next Annexure PN4, which begins on page 15? Are you there, please?
I'm there.
Thank you.
I'm there, ma'am.
And for context, we're now in paragraph 29 of your witness statement on page 11. Again, my apologies. Please identify the title of the document on page 15.
The title of the document is Suspension Letter.
Thank you. And the date reflected there, Mr. Ngiza, according to your witness statement, there's a slight correction you would like to make?
Yes. That this is a suspension letter that I drafted on the 24th of February. Unfortunately, it's reflecting 20th February on the letter itself, but it was actually on the 24th of February. And you can also discern that from even the contents of the letter. The letter could not have been drafted on the 20th because the letter refers to an event or process that had occurred on the 22nd.
Okay. I'll take you to that specific part of the letter now, but can you confirm that the suspension letter relates to Mr. Julius Mkhwanazi?
Yes, it does.
Thank you. Mr. Ngiza, the first paragraph of the letter, could I invite you to read that first paragraph, please? Beginning the notice of?
The notice of intention to suspend you issued by the municipality on the 21st of February 2023, as well as your written representations dated the 22nd February 2023.
So we can glean from that first paragraph that Mr. Mkhwanazi made written representations in response to the pre-suspension letter
Yes.
on the 22nd of February 2023.
Yes, it did.
And therefore the date of the suspension letter therefore could not be the 20th of February 2023. Is that correct?
It most definitely could not.
Thank you. In paragraph 2, the letter then responds, or the letter then says, the notice served upon yourself called for submissions of written representations in respect of a determination of whether to suspend you or not. Do you see that?
Yes.
Thank you. Please read the contents of the third paragraph.
The third paragraph,
Yes,
the
please.
submissions.
Indeed, yes.
The submissions received from yourself do not in any shape or form provide reasons why the employer should not place you on suspension.
And you then cite the authority for that in the next paragraph. Is that correct?
Yes.
My apologies. And in paragraph 5 provides that the employer hereby suspends you from work pending the investigation and conclusion of any possible disciplinary proceedings that may ensue in terms of the provisions of the disciplinary procedure collective agreement. Is that correct?
Yes.
Thank you. And you then set out the reasons there warranting the suspension.
Yes, ma'am.
Thank you. Paragraph 6 then at the foot of the page sets out the conditions that apply in respect of the suspension.
Yes, ma'am.
Can I ask you to flip the page then to page 16,
Yes, ma'am.
where I'll ask you to again identify the respective signatures on that page.
The signatures that are on page 16, commissioners, are myself, Olaning is at the Employee Relations, Ms. Linda Kasheka, acting HOD, Human Resources, and acknowledgement of receipt by J.D. Mkwanazi with his signature and the date that he had received, which is the 24th of February 2023.
Mr. Ngiza, if I may confirm then, the date of signature of the suspension letter would then be the 24th, correct?
Yes.
Right. And the subject matter of the investigations at this stage is based on a preliminary investigation at this point, is that correct?
Sorry,
Meaning
ma'am?
the allegations under consideration at this point are based on the preliminary, yes, the
Yes.
allegations that make up the subject matter of the suspension at this point are based on the preliminary investigations that have been reported to you at this point.
Yes.
Thank you. All right. Could I then ask you to turn to page 12 of your witness statement? Could we go back to that file? Page 12 of the witness statement, and you are in paragraph 30.
Yes,
Indeed.
I am.
Thank you. And in paragraph 30, you indicate that Brigadier Mkwanazi was suspended for 3 months in terms of clause 16 of the DPCA, that's the collective agreement referred to in the suspension letter, which suspends him from work pending the investigation and conclusion of any disciplinary proceedings. Is that right?
Yes, it was.
So if his suspension date was effective from the 24th of February, the suspension would then be effective for the next 3 months up to May, correct?
Yeah, 24th May.
Thank you. Please then take the Commission through the subsequent developments after the issue of the suspension letter. You are now at paragraph 31 of your witness statements.
31.
31 on page 12.
So, just for clarity, I need to take the commission, the subsequent developments on this matter of Mkwanazi.
Indeed, following the issue of the suspension letter.
Commissioners, as I proceeded to, of course, deal with my other duties in the institution, which was involving all departments in the institution, but there is an acknowledgement that I've always had that EMPD had the highest number of disputes in the institution, disciplinary matters, I think, because of the nature of the work that is performed by Metro Police officials. You know, they are working with the members of the public, so you would have all sorts of allegations that get raised, whether it's issues of assault, it's issues of bribery, it's issues, you know, that concern the conduct and behavior of the Metro Police officials. So I would then regularly engage with the department on matters that impact discipline in the department. So we had a number of briefings that ensued in respect of especially the investigations in Brigadier Mkwanazi's unit, the investigations into the blue light scandal, but they also raised issues with me regarding other investigations that were underway, inclusive of investigations against Mackenzie, Stones and Twala, you know, who were constables working in the specialized unit section. Now, during those briefings that I would receive, I would say that I received what I can only term and describe as horror stories, you know, about what was happening within the unit, and I was kept abreast of even engagements that the chief of police was having with IPID regarding these officials, Mkwanazi, Mackenzie, Stolz, and Twala. So, yeah, I received a lot of information about the cases that were dealt with, issues of copper, theft, issues of even murder, extortion. There's a number of issues that they briefed me about regarding these individuals.
The information you received relating to these 3 other officers was just as serious as the information relating to Brigadier Mkwanazi. Do you know why they were not suspended or even issued with a letter that requires them to make representations regarding why they should not be suspended?
My recollection, Commissioner, is that indeed they were suspended. There's a point where we suspended them. There's a point where I recall that I even instituted disciplinary proceedings against them. I did institute disciplinary proceedings. I appointed the Disciplinary Tribunal Committee, and the process was to commence. And I later learned that indeed there were problems with regards to the processing of their case. At some point they were arrested, so the action was taken against these 3. It's just that it was not taken forward, but my office had instituted proceedings against them. But I understood later on that there was a problem with the presiding officer because he was not paid by the municipality for other matters that he had done for the municipality. So he had served some notice to the attorney to say that he is not going to be able to proceed if he does not get paid for his services that he had rendered to the municipality. That is a big problem, of course, the payment of attorneys for services rendered. But action was taken against these 3.
Thank you, Commissioner.
If I may, according to the evidence, so far, the conduct or the misconduct of these 3 officers came to light because of IPID's report, once there was engagement with IPID. Now, internally in the municipality, at least up to the time that you were there, was there a process or a mechanism where employees can report concerns about the conduct of people such as this, the conduct that subsequently came to light through IPD? Was there a mechanism for employees to do that and to do that in a safe way?
The municipality, Madam Commissioner, has a whistleblower policy. I'm the first to admit that it had not been used or utilized by the municipality to its fullest. But the municipality has the whistleblower policy. It's even on the intranet of the municipality. There were campaigns at some point by our communications department to promote, accessibility to whistleblower processes. And we've had a number of instances in the municipality where we've had whistleblowers. We investigated the issues that were raised by whistleblowers, and indeed action had been taken against officials on the basis of whistleblower processes. Now, on these specific ones, you are correct that indeed we came to know about their activities as I was briefed through IPID, But what happens is when we've got matters that concern Metro Police officers, you would have 2 types of investigations. You would have the internal affairs investigation or integrity and standards, and you'll also have an IPID investigation. Now, if you have an IPID investigation, the department would then do a cover letter in that form that says we've got this investigation with its annexures, therefore bring it to me, but I would need something from the department because the department has to take ownership. Even if it's an IPID investigation, the department must take ownership So then the chief of police will then bring to me a request for a disciplinary tribunal, and in that request they would indicate that here is an IPID report that has a negative recommendation against this officer. So therefore, as labor relations or employee relations, you need to take this forward. There will be that request to initiate what you call disciplinary proceedings against that particular employee. So if my recollection serves me well, that is what would have happened here. They would have provided me with an investigation report, and then I instituted the disciplinary tribunal.
Thank you, Commissioner. Just to close off this aspect of your evidence, Mr. Ngiza, at the end of paragraph 34, the last sentence then, you confirm that you were informed that in addition to investigating these criminal offences, the ones discussed above, IPID was also investigating the role of Brigadier Mkhwanazi in the Blue Lights scandal. Is that correct?
Yes, I was.
Yes. And that in the paragraph above, 33, you were informed that even though, your discussion related primarily to the issue concerning the Blue Lights, the IPID discussions had revealed that there was a broader problem involving further police officials, and that was brought to your attention.
Yes, it was.
Okay. Mr. Ngiza, we are then beginning a new subheading entitled Disciplinary Tribunal. This is paragraph 35 of your statement. We're still on page 13. Once you are at paragraph 35,
I'm there.
thank you. Could you please describe to the Commission the developments of that day? Paragraph 35.
Thank you, Council. On the 12th of April 2023, Chief Mapieye, Commissioner Spies, and Lieutenant Colonel Erasmus came to my office, and they presented to me what they term a docket that contained the investigation report onto the allegations that were leveled against Brigadier Mkhwanazi. We went through the report, and of course I engaged them on the content to say, but we're talking about this letter of October 2021, what are the issues? And then I approved that a disciplinary tribunal be constituted, because they had, in my view, the investigation report ticked the relevant boxes that would convince an HR practitioner that there is a basis for this employee to answer to these allegations that have been leveled. So indeed, after we had consulted, I appended my signature to the disciplinary tribunal initiation form, and then we also then discussed how to handle the process. They raised issues with me to say, as much as they had briefed me on several occasions around the matters that concern Mkhwanazi, Mackenzie, Stolz, and Twala, and there was also some process that had started with regards to the other three, they indicated that IPID was confident and convinced that there were imminent arrests that would be made, which would include Brigadier Mkhwanazi. So they requested that instead of proceeding, as much as I've approved the disciplinary tribunal, but I must provide them and provide IPID with an opportunity to conduct these other processes, and then we will then assess the situation. If indeed there are arrests that are made, then it might not be prudent for me to institute an appointed disciplinary tribunal, because there are timelines. The minute you have appointed a disciplinary tribunal, there are timelines that must comply with in respect of the collective agreement. So we need to play this in a manner that we are able to ensure that we don't incur even some fruitless expenditure, because you appoint a disciplinary tribunal for a matter like this, and then people start working, and then the person gets arrested, you can't even proceed with the disciplinary inquiry and still be expected to pay for the services that you would have sort of incurred from attorneys and the likes. So that was the discussion on the day. And lastly, in the discussion, we decided that they must actually keep the docket because of the contents thereof, and I didn't want it to lie around in my office. I just needed it to be kept in the safe arrangement.
Thank you, Mr. Ngqiza. Commissioners, before we proceed on this issue, I'm going to request that these documents are handed up to you by our attorney, please. They somehow seem to have not made it to the annexure file, but we'll attend to sorting that out over tea. Thank you. Thank you. Yes, each of them will get like that. Okay, perfect. Thank you, Commissioners. The documents presented to you are numbered 15A and 15B, and we'll paginate them properly and insert them at the right place in your files. For now, we're going to make reference to them in this course of Mr. Ngqiza's evidence. Mr. Ngqiza, could you confirm that you are in possession of the two documents handed up to the Commissioners? 15A is titled Directive for Implementation of the New DPCA. Do you have that document?
Dated the 15th of February 2018.
Thank you.
Yes, I have it.
Thank you. And then the second document is a document from the South African Local Government Bargaining Council, Circular number 1 of 2008. Do you have that document?
2018.
8th of February 2018?
Yeah,
Thank
I
you.
have it.
Thank you. Thank you, Commissioners. Okay. Mr. Ngqiza, could we then turn to, if we could take a few steps back and return to paragraph 36 of your witness statement, where you say, I concluded that there was indeed a case warranting that a disciplinary tribunal be constituted. Do you see? Can you confirm that?
Yes.
Thank you. If I could ask you to have regard to circular number 1 of 2018, that's the DPCA itself.
Yes, I have it.
Thank you. You'll see that there's an index describing the issues that are regulated by this document. Could I?
Yes, I'm there.
Are you there? Thank you. We're going to focus specifically on clause 7, which relates to disciplinary procedures, in this case, as they regulate a municipality. But I would ask you to please turn to clause 4, which is on page 4 of that document.
I'm there.
Thank you. So, clause 4 would regulate the period of operation, right? So, the DPCA, as it applies, sets out the period in which it operates. Could you just record for the record what that period is?
On clause 4.1 of the agreement, the period of operation is from the 1st of February 2018, and it will remain in force and effect until the 31st of January 2023.
Thank you. Are you able to confirm to the Commission its status here today? So does it still apply?
Yes, it does, because after the date of 31st January 2023, it then says, thereafter, the agreement shall continue indefinitely in respect of the parties to the agreement.
Thank you. And for completion in respect of this document, the DPCA is the same document that you reference in your witness statement as providing for the suspension. In particular, you cite the letter of suspension cited clause 60. Is that correct?
Yes, it is.
Yes. So the document regulates several processes from a bargaining council level, and we will consider specifically the issue of disciplinary procedures. Is that right?
Yeah.
Thank you. Mr. Ngiza, I'm then going to ask you to turn in the same document to clause 7, which begins on page 5, clause 7.
Yes,
Thank you.
I'm there.
And clause 7 is entitled disciplinary procedure. Could you read into the record the contents of clause 7.1, please?
An allegation of misconduct against an employee shall be brought before the municipal manager or his authorized representative for consideration and decision.
Thank you. And who is an authorized representative in this context, in the Ekurhuleni context, as an example?
Like I said yesterday, commissioners, how we apply this collective agreement in the municipality, we have sort of categorized it. You know, you would have an authorized representative, as envisaged in clause 7.1, would be the head of department. But an authorized representative, as you go on with the collective agreement, would change. You know, it's not a one person. It's not one person. In other municipalities, you might find that it's the municipal manager or this particular person who will be responsible for all the issues that concern a collective agreement. But in our city, we didn't do it like that. We sort of decentralized the processes in terms of our delegations matrix. So in terms of 7.1, it would be the head of department as an authorized representative.
Thank you. See, paragraph 7.2 reflects a principle then that disciplinary proceedings are to proceed promptly without undue delay. Is that correct?
Yes.
Indeed. Then paragraph 7.3 provides that if the municipal manager or his authorized representative is satisfied that there is a prima facie cause to believe that an act of misconduct has been committed, he may institute disciplinary proceedings against the employee concerned. Is that
Yes.
correct? Okay. Could you just briefly explain how that applies in practical terms to the Commission?
In practical terms, this would be, you have an allegation of misconduct that has been received in the department then, in terms of the consideration of the allegation, the department would then institute an investigation. And having instituted the investigation, having then received the outcome of the investigation would show that there is indeed a prima facie basis for you or prima facie cause for institution of a disciplinary process. So then the department would submit to my office. Once they've got that prima facie cause, then they would submit. They would not themselves institute the disciplinary process.
Could I ask you to turn to the next page? Clause 7.4, which provides that the disciplinary hearing shall commence as soon as reasonably possible, but no later than 3 months from the date of the municipal manager or his authorized representative's decision to institute disciplinary proceedings.
Yes.
Thank you.
So once indeed the investigation has been concluded and the submission is made in terms of the initiation of a disciplinary process, the authorized representative has got 3 months within which to constitute the disciplinary proceeding.
Thank you.
The disciplinary tribunal.
The next 2 paragraphs then posit 2 options that are available in the event of misconduct. Paragraph 7.5 regulates misconduct that appears to be less serious. Is that correct?
Yes.
Indeed. And then paragraph 7.6 regulates misconduct that appears to be sufficiently serious.
Yes.
Indeed. And what is the course or avenue to be followed according to clause 7.5, where the act of misconduct is one that appears to be less serious?
Where indeed the act of misconduct is less serious, like I had explained, this is an instance where a probable sanction would be a written warning. Therefore, would either have a counseling session or else just issue a written warning to the employee. That is handled as a departmental inquiry, is handled internally by the department. It does not really require that I establish a disciplinary committee. So that can be handled by the department at a departmental inquiry level.
And where the act of misconduct is one that is more serious, what is the route that is then followed?
The route that is then followed is that the department, having submitted the investigation report, and if indeed, having applied my mind, I consider that indeed this matter requires a disciplinary tribunal, I would then authorize that a disciplinary tribunal be constituted, and having authorized that it be constituted, I then have to move forward to implement the appointment processes for the disciplinary committee.
And those processes are set out in clause 7.6.1. Do you see that, Ms. Angeza?
Yes.
Thank you. And could you just briefly explain the contents there of who is to be appointed and the alternative appointment that is available in the event that a disciplinary tribunal is authorized?
Thank you, Council. You would find, Commissioners, that 7.6 and even 7.7, how it's structured, it has a default position. The default position in the constitution of the disciplinary committee is that in the first instance, you shall appoint a person internally, and in respect of this, what we did as an institution in my tenure as the divisional head, we had a panel of people that were trained as presiding officers as well as employer representatives. So if we get a request from a department to constitute a disciplinary tribunal, would look at firstly the merits of the matter, what type of case is it, what is involved, the level of the employee, and the likes. And then we would then look at our panel. Are we able to find a suitably qualified person in our panel to deal with this matter? Now,
and you are still talking the default position there.
Yes, that's the default position.
So the panel would be people within
the default position.
The municipality.
The municipality. Our panel is people that we've trained in the municipality. And I need to admit that as much as we had done much in terms of in building the necessary capacity internally, you would find that your senior people from divisional head and HOD level, really do not have time. They simply do not have time. Their demands on their jobs are much higher, and therefore they would not automatically be available or readily be available to firstly go for training. And even if they do go for training, a whole lot of them, even if you appoint them, I promise you, you are just simply not going to get the person to give you time. They've got a whole lot of things, service delivery imperatives would take precedence. Now, the collective agreement 7.6.1 is clear. When you appoint a presiding officer, the person must be at least 2 levels above the person that you are intending to charge, the accused employee. So you need then to zoom into this particular matter. If you were to appoint a person internally, you would have to appoint an HOD. Because the brigadier level, and you will see in the suspension letter, it states that it's a C17. The C17, in terms of our job evaluation processes in the municipality, was the highest level that was evaluated for your bargaining unit employees, for your permanent staff establishment.
I'm sorry to interrupt you, Mr. Ngiza. Ms. Mushasedi, do we want to discuss the terms of this agreement as generally as we are now, or do we want to zoom in on what was relevant to the case of Brigadier Mkwanazi?
Thank you, Chair. Yes, our aim is to discuss the two of the documents in the context of what was relevant here in two respects. Firstly, the constitution, or rather the appointment of an external chairperson and an external prosecutor, which will become relevant during the course of Mr. Ngiza's evidence. The second important issue is who exercised or who bore the power to determine whether to constitute a disciplinary tribunal, and the documents are relevant for that assessment. I will endeavor to be very brief. I'll pose direct questions to
Yes,
them.
I'm asking, for example, because as I understand the evidence here, people external had to be appointed. And I think that focus on the appointment of external people and why it had to be external people should be enough without us getting into the situation where internal people would be used and why. Did you see what I mean?
I follow. Thank you, Chairperson.
Yes, thank you.
We'll
Thank
direct the exchange in that manner.
Thank you.
Thank you. Mr. Ngiza, then my final question with respect to the collective agreement would be in respect of clause 7.6.3. You've indicated then that as a general rule, when constituting a disciplinary tribunal, the effort would be to obtain an internal candidate to act as a chairperson or as a prosecutor. Is that correct?
Yes.
Indeed. And then where that is not available, where an internal candidate is not available or not possible, there are certain circumstances where you would obtain a chairperson or a prosecutor who is an external person.
Yes.
Correct. And in paragraph 7.6.3 reads that where there is a lack of suitably qualified persons or where the presiding officer is threatened or intimidated, the municipal manager or his authorized representative may appoint a suitably qualified external person. Is
Yes,
that correct? Thank you.
Yes.
And is it then fair to say that that exception or that alternative applies to the appointment of a chairperson as well as to the appointment of a prosecutor in a disciplinary tribunal?
Yes, it does. It's just that with regards to the appointment of a prosecutor, the collective agreement provides for additional considerations.
And what would those be, briefly?
Whereas the collective agreement does not speak to the presiding officer in respect of legal practitioners, it speaks to legal practitioners in respect of a prosecutor. And the fact that if you are to appoint a legal practitioner, then there should be an agreement between the parties, or alternatively, you should then apply to the presiding officer for the legal practitioner to represent the municipality.
Thank you. But, and just to confirm then, that even with respect to a prosecutor, where a suitably qualified person is not available or there is an issue, a concern around a threat or intimidation, an external prosecutor may be appointed?
Yes.
Thank you. Mr. Ngiza, I would then ask you to have regard to the document numbered as 15A.
Which one is that?
It's the document with the subject directive for implementation of the new disciplinary procedure collective agreement.
So he has gone to the bathroom.
What's that?
Accused number 2.
I have the document, but it's not
Yeah,
there.
they've just
My apologies.
taken him
You can just
downstairs.
number that 15A. It shouldn't be, it's all right. We'll handle it for you over the tea break. It's all right.
I'm on it.
Thank you. And just to confirm, that document is a memorandum issued to all HODs and employees, and it cites their 2 unions. Do you confirm that?
Yes,
Indeed. Do you please confirm where the document originates from?
it originated from the HOD HR, Head of Department HR.
Thank you. And the emblem on the top right of the document reflects that it applies to which particular entity, please?
City of Ekurhuleni.
Thank you. And the date is?
It is the 15th of February 2018.
Thank you. Which is subsequent to the circular you've just taken the commission through.
Yes, ma'am.
Thank you. Could you just explain briefly what the purpose of this document is and how it is to be considered in light of the circular we've just discussed?
This document talks to the internal arrangements that I had spoken to earlier on in terms of how we as the City of Ekurhuleni implement the disciplinary procedure that is contained in clause 7 and other clauses of the collective agreement.
Thank you. Mr. Ngiza, could I ask you to turn to paragraph 5 of that document, please? Paragraph 5.
Yes, I'm there.
Paragraph 5 is entitled, "The following principles shall underpin the implementation of this DPCA."
Yes, ma'am.
Paragraph 5.1 reads, "An allegation of misconduct against an employee shall be brought in writing to the city manager or his authorized representative." Is that right?
Yes, ma'am.
And the authorized representative in this case applies to who? You indicated that it might change in certain contexts, but here, within the context of an allegation of misconduct,
Would
who
be the
is-
HOD,
would be
Head
the
of
HOD.
Department.
And based on our current facts under discussion today, that would be, for example, Chief Mapie.
Chief Mapie, yes.
Thank you.
Continue.
Thank you, Chairperson. Paragraph 5.2 then reads, "A supervisor or another employee investigates the allegation of misconduct and submits the investigation report with a recommendation to the relevant HOD."
Yes, ma'am.
In the context of the facts under discussion today, who would be the supervisor or employee tasked with the investigation of misconduct here?
Under these circumstances, the employee would be
Accused number 2 is now
Lieutenant Colonel
present.
Erasmus.
Who you confirmed earlier
Thank you very much for
is from the
indulgence.
Integrity and Standards
Thank you,
Division.
Mr. Silia. Just a step back, just
Paragraph
one step.
5.3 then sets out the next step, and it says, upon
About this
receipt
impure
of the
utilities,
investigation report, the relevant HOD,
There is
who I
information
now
that was
understand to be
read to
Chief
record
Mapie,
allegedly that came from him.
shall complete
When
and submit the disciplinary
Mr. Ngomezulu was
initiation request
cross-examining
form
Mr. Kininda.
to the DH Employee Relations
Part of that,
for the
that was
initiation
written to
of
record
the disciplinary
something that came
proceedings.
as
Is that right?
something
Yes.
that came from the
So,
this impure.
In terms of this
Was that around
paragraph,
January 2020?
Chief
He
Mapie
went to Force Flores.
should then contemplate
had-
that Chief Mapie
I don't
should
know
then
from who,
complete
but
and
he had
submit the
that
disciplinary
you had a quarrel
initiation
with your
request form
girlfriend about
to the
Senzo Meyiwa,
DHER,
and that your
who
father
is-
paid some
Myself.
Thank you.
money over to the police so
And
that
critically,
the
it says
case
initiation
should not go on.
request.
Do
Indeed.
you have any comment on that?
Indeed. And then for completion on this note, paragraph 5.4 says the office of the division head ER shall identify and appoint a presiding officer and employer representative. Is that right?
Yes.
So, Mr. Ngiza, these documents then read together set out a procedure for the
ukuthi wena-ke
institution
wawuxabana
of
nomukulwa owawunabo,
a, rather let me say, the
nowawuthandana
constitution
naleso
of a
sikhathi
disciplinary
leso,
tribunal.
mayelana-ke
Is that
nodaba
correct?
lukasenzo
With
nokuthi ubaba wakho
the
wakhokha
idea
imali
that an
emaphoyiseni,
allegation is presented to
mayelana
an
necala
HOD,
lelo. Khona
who
okwaziyo
then
mayelana nalelo.
In
appoints
fact, before you
someone
answer,
to investigate
he also says
the
that
allegations and
he
submit
also
a
heard
report,
that your father paid money
and that
over to the
report
police
is
for the case
then
not to
accompanied by a
Ngaphambi
request
kokuthi
to
uphenduleke, okunye
yourself
akusho
for the
akushilo-ke futhi
initiation
yena,
of
sakhuluma
disciplinary
ngaye-ke
proceedings.
uButhelezi
Is that a
lona,
fair
ukuthi
reflection
wezwa
of
nokuthi
the
ubaba wakho
content of the
kunemali
document?
ekhokha emaphoyiseni ukuthi icala lingaqhubeki.
On that
comment?
note, could I
Khona
then
ungakusho?
Nani ngishilo la
Ask you
umshushisi
to
engibuza
turn.
ukuthi ethi
Have regard
engifundela yona lento le
to
athi ayibhala uSinphiwe ngamtshela ukuthi uSinphiwe ngimazi and akazi kuze kwenzeke kube
witness
nemali
statement
ubaba
again,
ayikhokhela ukuthi
where
kube
we are now
necala
on
elingaqhubeki
paragraph
ayikhokhela amaphoyisa
38.
and ayikho intombi engangaqabana nayo ayikho
Paragraph
intombi
38.
enolwazi njengoba nami ngingenalwazi njengokufa kasenzo ayikho intombi yami enginayo and 2020 mina bengihlala eThembisa abangiboshwe 2019 nje ngiboshwa ngihlala eThembisa ngaphinde 2020 ngiboshwa eThembisa ngangihlala eThembisa ngangasenayo intombi ehlala eFosforus.
When this was read to me by the state,
and at paragraph
I did say
38,
that
you say there,
I know
on
nothing
the
about
same
this.
day,
I know nothing
I
about
signed
any
the
money that was
approval
paid by my
of the
father
recommendation to
for a case to
constitute
disappear. And there is
the
no
tribunal
girl
within
that
3
had
months. Is that
information,
correct?
which I also information
You make
which I
reference
also don't
there to an
have,
annexure
have about the
PM6.
killing or the death of Senzo Meyiwa. In 2019, when I was arrested, I was staying in Tembisa, and
On
again in
page
2020, I was still
288
staying in
of
Tembisa.
the annexure bundle.
And
Sorry, sir.
PM6.
Are you kidding?
Akunayo intombi ehlala
Yes.
eFosforus.
I do not have
Thank you. Page
a
288
lady, or I was
of
not
the
involved with
Annexure
a lady that
I
stays
just
in
ask you to put your
Phosphorus.
finger there so that we
yeah,
can place
and
the full
with
document
this
on
question,
record.
I should not be construed to validate anything, the truthfulness or otherwise
If you flip
of the
one page
information
back
that
to
was
the
read
front
into
of
that
the document.
record. Do you understand?
Ngakho-ke lokhu asibona ukuthi-ke ufuna
287.
ukuthi ngivezeke uliqiniso
287,
mayelana-ke
one page
naso
back
leso
is the
statement
first page of
leso
the document,
noma ukuthi
and
siyiqiniso kangakanani lokhu
It is
okwakufundiwe.
titled
Ngalo
Request
mbuzo
for
akusiyona inhloso
Disciplinary
yami lokho.
Tribunal. Is that
Thank
correct?
Thank you.
Yes, ma'am.
Thank you. At the top of the page, it is directed to yourself. Is that
to-
correct?
Yes, ma'am.
The
It originates
extracts
from
of
the
Brigadier
Chief of
Kininda's
Police, Mr.
diary.
Isaac Mapieye. Is that so?
Now,
Yes, ma'am.
Who you've identified as
under
the HOD
cross-examination,
referenced
you
in the
put
documents
to
we've
you
discussed.
that
Yes.
Brigadier Kininda was
The document
noted
then sets out
and
that an
everything,
accusation of misconduct is brought in
or
terms of the
noted
disciplinary
what
procedure
was happening
against Mr.
as
J.B.
he
Mkonazi
spoke
as the
to you,
employee.
the
Is
reading
that
of your
correct?
rights, the warnings that it gave you, all those
Importantly,
things that the state alleges Brigadier
Mr. Ngiza,
Kininda did.
Umbuso-ke ushilo kwena-ke
The
ukuthi-ke
document continues to
konke
identify the
okwenzeka-ke
nature of the
phakathi
alleged
kwakho
misconduct.
noBrigadier Kininda
But
owayekhuluma
I would
nawe,
ask you
uchazela amalungelo,
to
ukuthi konke
return to
lokho
page
wayebhala
288,
phansi
to flip
Brigadier
over to page 288.
Now, did Brigadier Kininda
Under
invite
recommendation
you
at the top
as a
of the page,
confirmation of the conversation that you
the
had
document
with him
provides
to come
for
and
two
sign,
options. The first option one is
on
a
his
request
diary,
for permission to
that
hold a
which he
departmental
wrote is a
inquiry,
confirmation of
and
what he
option
did to
two
you.
is a request
Ingabe-ke
for the establishment of a
nanjengokuqinisekisa
disciplinary tribunal.
ukuthi ngempela-ke
Do
lokho
you see that?
ayekhuluma
Yes, ma'am.
nawe
Thank you.
wayekubhala
And at the
phansi
bottom
wakubiza
is
yini noma wakucela
a
yini
straight line that
uBrigadier
makes
Kininda
provision for
ukuthi
a
uze-ke
signature.
kule
Could you
ncwadi
identify
yakhe
the
ebizwa
signatory
ngokuthi
there, please?
idayari, uzosayina
signature there
kuyona
is
uqinisekise
one of
ukuthi ngempela
Chief
lokhu ayekhuluma
Mapieye.
nawe wayekubhala phansi wakwenza yini
And just
lokho?
above, as
Cha,
contained
ngoba
in
ngisho
that box,
ukuthi ayikho into
what
ayibhala
is
phansi,
the
sikhathi
recommendation
ekhuluma nami.
that
Akaze ezekwenza, akaze
Chief of
ezebhale
Police
phansi, sikhathi
Mapieye
ekhuluma nami futhi.
made
No,
or
as
sought
I said, that
in-
there was nothing
and
that
directed towards you?
Kininda reduced
Chief
to writing,
Mapieye had
which he
ticked
was
the second box,
talking to me
which is
about.
for a request for the
never
establishment
happened.
of a
He never
disciplinary
wrote
tribunal.
anything down.
At the
Thank you,
foot
Mr. Sylvia.
of the page, you will see then a signature. Could you identify the signature? Who signed there, the signatory?
Now,
Signature at the bottom of the page is mine.
And could you identify the content of the boxes
in
just
your-
above the signature?
In
There are
cross-examination,
3 boxes above the signature. There is further investigation,
It was also
mental
put to
inquiry, and
you
disciplinary tribunal.
Thank you. And
that
which of the
the
boxes did you tick in indication
arrest
of your approval?
in
Disciplinary
2019
tribunal.
Thank you.
by,
For
amongst
completion,
others,
Mr. Ngiza,
Mr. Baloyi,
yesterday
one of the police
you
who came to
engaged
arrest
with
you,
Commissioner Baloy
Never
about the
happened.
options available to the head of employee relations once they receive an
I'm saying
investigation
it
report,
was
the so-called docket.
put to you
And you indicated that there are
that
3 of those
the
options.
arrest in 2019
Having gone through
that was
the contents of
inflicted
the
on you,
collective
amongst
agreement,
others,
you've explained that
by a
a
policeman
departmental
called Mr.
inquiry
Baloy never
is
happened.
suitable in instances where the allegations
That
of
is not
misconduct
correct.
are of a
That
less
is not
serious nature. Is
what
that right?
we put
Whereas
to
a
the witness.
disciplinary tribunal is most suitable where
What
an
we joint
employee
issue
is facing
with
particularly serious
Mr. CBS
allegations of
as to
misconduct.
what
Did that
happened
distinction then affect
when
the decision that you
he was
ultimately
talking
took
to
when considering this
Klurkov.
request from the chief of police?
That was the
That
basis on
distinction
which
always
we
affects the decision
cross-examined
that
the
one makes.
witness.
Because you have to weigh the evidence in the merits of the
Thank you.
case as
I
presented in
understand
the
the
investigation
state to
report
mean
before you go
that
and tick the box.
apparently they don't dispute. Actually,
And
I don't
in-
understand what's
in considering the
basis of their
You know, the
defense
weighing up
is,
of the
I mean,
evidence
of
that
their
was
objection is.
provided to you.
But I would then assume
You annex-
that they mean
At
that
paragraph 37 of
that
your
arrest
statement, you
actually
annex
happened.
the
I don't know
investigation
if the
report
state
that was
can
provided
clarify
to you.
on that.
Do you see that? Paragraph 37
Well,
of
the evidence is
your
there, the
statement on
record
page
is there.
13.
It's not for us to explain to
If I
counsel
ask you
what
to
happened.
flip over
We
the
must
page,
cross-examine
you
on the
then
basis of
informed
what
the
is on
commission
record and
that
what took place.
Upon receipt of that report, you considered its
Now,
contents
this issue
and then you signed the
of the
approval
Buthelezi brothers,
to constitute a
you
tribunal.
got confronted with
And in
as
the
early as 2019
paragraph
or so.
immediately thereafter,
Manje-ke udaba lolu
you set
lalaba
out briefly
ababili-ke
the justifications for
Into-ke
why
lena
you were
abaqala
minded
ukuthi
to
bayikhulume
sign
kuwena
the
noma
recommendation to
bakhulume
constitute
ngayo
the
kuwena
disciplinary
ngo-2019.
tribunal.
Yeah.
Yes.
Yes.
When you were arrested in 2020,
Now, Mr. Ngiza,
you also got confronted
the commission has, over the course of the past few
about
days,
this issue of
heard extensive evidence
the
from
Buthelezi brothers. Now, so.
Commissioner
Waphinda
Spies as
futhi
well as
uma uboshwa
Chief
ngo-2020
of
baphinda
Police
futhi
Mabiyeye
babuza-ke ngalo
about
udaba lolu lwalaba ababili bakwaButhelezi.
their
Yeah,
view as to why the
Yes, they told me about it.
allegations as they
And
relate
this is
to
information
Brigadier
that you
Mkhwanazi
say
were
it
warranted.
has always been introduced
and
to
therefore
you by the
justified the
police.
taking
What
of
is it that you
disciplinary
know
steps.
about the
But you also
Buthelezi
set
brothers?
out in your
Uyasho-ke
own
wena
what
ukuthi
motivated
into lena noma
your
inkulumo
decision to
lena-ke ngaso sonke
constitute that
isikhathi
disciplinary
ibilethwa
tribunal.
kuwena noma ibishiwo
Could I
kuwena
ask you then
amaphoyisa
to
wena-ke
turn
yini
to
oyaziyo
paragraph
ngalaba bakwaButhelezi?
39.1?
No, I'm saying
Paragraph 39.1
they've
of
always
your
been
witness
asking
statement.
him what is it
Are you
that
there?
he knows
Yes, I'm
about the Buthelezi brothers.
ukuthi-ke ngaso sonke isikhathi bekuwamaphoyisa la
If I can
aza
assist
kuwena
you,
nale nkulumo ukuthi wazini
please
ngalaba
turn to
bakwaButhelezi.
Yeah.
36
Thank
of
you.
your annexure bundle.
Now,
page
against
36.
that background,
36.
Yes, please.
there are statements that were written to record, allegedly made by you, by the state, wherein the names of the Buthelezi brothers are also mentioned.
Manje-ke kuney'tatimende ey'fundiwe-ke la enkantolo
Thank you.
efundwa-ke
So-
shushisi-ke kulezo y'tatimende lezo-ke
To locate this discussion in-
okukhulunywa ngaso noma-ke wena-ke owakhuluma
In the
ngazo
context of your
ukhuluma
annexure
ngalaba
bundle.
ababili bakwaButhelezi.
You've annexed annexure PN5,
No,
which is the
I'm not saying he
investigation
made statements.
report.
I'm saying allegedly
Thank you.
information that was introduced by the
You've
state.
confirmed that that is the report
wherein
that was
those statements
provided
wherein the
to
Buthelezi
you
brothers are mentioned.
On the
Yes,
12th of April,
statement
thank you, and that
efundiwe lana.
it is the report that was provided, or rather
Lapho
prepared
khona-ke
by
laba
Colonel
ababili
Erasmus.
bakwaButhelezi
Is that correct?
ekukhulunywa ngabo
Thank you.
ngokusho kombuso.
You don't need to go
Thank you.
there.
Yeah.
Now,
On page
against the
21
background that
of the
this
annexure
information
bundle,
relating to
It sets
or
out
the names
a
of
list
these
of
Buthelezi
documents
brothers
that are relied upon in the
were first
compilation
introduced to
of
you in
the investigation
2019.
report.
when you got arrested in
So if at
2020,
any stage you require
the
assistance in
police
navigating
also
those
confronts
documents,
you
I'll assist you.
about your knowledge of the Buthelezi brothers, and subsequent thereto, there are statements
also
that are
note
made
for you,
before court,
Mr.
I mean,
Ngiza,
that are
that
read
the
before court that are coming from the state, wherein the Buthelezi
Docket or
brothers
the
are
investigation
mentioned.
report
What can your comment be
provided
in
to
that
you
regard?
is some 250 pages, so it's a comprehensive document. But you've done the task of isolating several documents that you wish to talk through today. Is that right?
Yes.
Boshiwe ngo-2019
Would that
buza into eyodwa
overview
ngalaba bakwaButhelezi
provided-
nango-2020 futhi kwane-statement eyifundwayo
Could
la
you then
enkantolo la
go
khona-ke
to page
bavelayo khona laba
36 of your
bakwaButhelezi.
annexure bundle, page 36?
The last question is what
Isn't
can
there, Ms. Mutlaseli,
What can your comment be in that regard?
uthini-ke wena
Or what is your comment?
I apologize, Chairperson, that's the...
engakusho ingoba
quality as
amaphoyisa
provided to
yiwo
us. Yes, indeed.
anolwazi ngabantu bakwaButhelezi.
The one on page 50.
What I can say is that
Same
the
as
police
one on
are the
page
ones
50.
that have got information with regards to the Buthelezi brothers.
Noma ingoba amaphoyisa efuna ukuhlanganisa abafana
Thank you, Commissioner. It's
abafana
larger. That is much
bakwaButhelezi
better.
nalento
Thank you.
le
Mr.
case
Mwiza,
lento
you've been
yokufaka
graciously
It
assisted
is because the
by
police-
Commissioner Khumalo. Please turn to page 54 of the annexure bundle, page 54.
Oh, yeah. Got it.
Thank you. Now,
It is because the
paragraph
police wanted to link the
39.1.
Buthelezi brothers with the sense of matter.
39.1 of your witness statement.
Yes.
Yes, you
Thank
set out
And you-
briefly
you-
there
you've been
one of the
consistent in telling this
considerations
court
that motivated you to
There is nothing that
constitute a
you said
disciplinary
that
tribunal.
came from your
Could you please
mouth
take the
that is
commission
contained
through
in
that?
those statements, not so.
Okushoyo-ke wena
Thank you,
ukuthi-ke
Commissioner.
ayikho into
Commissioners,
ephume kuwena noma eshiwo
My
kuwena
reflection
ngomlomo wakho
on this
ekhona
letter
kuleza
was
statement.
As
I
I
think out.
I'm sorry, not to interrupt. As a court,
First and
please,
foremost is
my colleague and
the
I
usage
checked
of
our
two
notes
titles.
and we cannot find any reference to the fact that
At the
Mr. Sibiya mentioned Buthelezi brothers during their arrest of
that there is
2019 or that he was
with
questioned
the signature
about the
and then it's acting
Buthelezi
deputy
brothers
municipal
in
police
2019,
commissioner
unless if counsel
/ brigadier.
can direct the court to the relevant portions
Now-
in the record, but we couldn't find reference.
I've been in
there to
HR management for more than 20 years. That does not happen. When you're acting in a position, you perform both functions
When you got arrested
of the
in
substantive
2019,
post and the acting position.
what was the content
So
of
if you're going to write a
the
letter in
interrogation
your
that was
capacity
done
as
to you by the
brigadier
police?
Mkhwanazi, you
Uma
write the
uboshwa
letter, you sign it as
ngo-2019
brigadier Mkhwanazi.
yini lena
Because
kule nkulumo eyishiwo
the-
amaphoyisa kuwena kwakuyini le eyishiwo
the
amaphoyisa kuwena
delegations, the authority that are in the position
Uma
of
ngiboshwa
brigadier,
2019 ngithatha amaphoyisa
Actually
angisethe
defined.
uqobo anguza
and you can
ngokufaka
exercise
senzo.
authority
When
up
I
to a
got
particular
arrested in
point as
2019
brigadier.
by the police, I was
But then
taken
when
to
you are acting in the
and
your
the
superior
police
position,
interrogated me with regards to
you then
death of
assume the
Senzo.
delegated
Bathi
authority
ngabulala
that
Senzo mina
resides
abafana
in
bakwaButhelezi.
that position.
In telling me
So if
that
you're going to
I
write a
killed
letter,
Senzo
You
together
must
with the
distinguish who
Buthelezi
is writing the
brothers.
letter. Is it the
But when I
brigadier
killed
who's writing the
Senzo, I
letter?
was with the Buthelezi
Or is
brothers.
it the acting commissioner
And
who's
it is-
writing the letter?
So, and
Because
correct
then
that
when
when that
if tomorrow there
interrogation
is
happened, you also got assaulted.
there's
Kathi
litigation
kwenzeka
about
lokho kwawushaywa nokushaywa.
Mr. Nziza,
Ngangishaywa nokushaywa ngibatshela ukuthi angazilutho mina
but he
ngokufaka senzo.
still
I was being
was a
assaulted
brigadier,
and
was he
informing
not?
them that I
Was
knew
it-
nothing about the death of
Aren't you
Senzo.
reading
Thank
too
you.
much then into this? Was he not
Um,
merely indicating his...
Let us now
his
proceed
ability?
to something.
With
else.
all due respect,
Just
Commissioner,
about to wrap our
it doesn't work like that. It doesn't work like that,
Our-
you know, because, like I say, different positions
engagements.
carry different
Now,
authority.
in Exhibit
So
GG,
if I am the manager, collective bargaining, and I'm acting as DH in
Paragraph
trade
12.
relations, if I write a letter that is within the scope of my function, my substantive position as
Mr.
as
Hadebe
manager collective bargaining, I will indicate
told this court
that this, because it talks to my substantive position. But if I'm writing a letter that speaks to the acting position that I'm
after
busy
the
with,
conclusion of
that
the
I'm
pointing
acting in,
out
then I must
of the
indicate
scene
the acting policy of the municipality states
and
very
for
clearly
points,
that when you are acting,
the
you
notes
perform both.
were read to the
You must
person
perform
who
the role
pointed
of the manager
out,
But
as
we-
well as
and
the
they were
commissioner.
interpreted
we
once again.
completely discount the possibility
You're on
that
page?
he could merely have been indicating
I
his
think there's a page 11, page
We
11.
completely discount that possibility.
I don't, no, I think that is, no.
I
this
wouldn't
thing is
completely
not
discount the
my page.
possibility,
I
it's
think
just that
there's
the
11
content
on
of the
top
letter then
there.
brings me to this.
Okay.
To say that in my view, this
There's
was
11 on
intended to
top
obfuscate
there, and
the
there's
role.
5 bottom there.
It was creating this
Yes.
Because at the end of the day,
On paragraph 12.
if for instance,
Ubaba
I'm to
uHadebe
deal with
ufakazi
the actions
wombuso,
of the employee,
ubhalwe
and if
lana
I'm to say, but
siyena-ke manje
you
exhibit
acted
G.
outside of your scope,
Emuva kokuseqediwe-ke ukuthi
I need to
kukhonjwe
understand exactly
indawo-ke
which scope you're
yesigameko.
acting. Were you acting as
Ama-notes
the
noma lokho
brigadier or
okwabhalwe
you acting
phansi-ke
as
kwafundwa
a commissioner?
kufundelwa yena-ke umuntu lo bekuyena obekhomba atolikwa futhi-ke kwase-ke kubuzwa le
Would you
mibuzo
have had the same
elandelayo.
concern
Thank you.
if he had signed, as he did there, if he
Now,
had said
this is
Brigadier
what
J.D.
Brigadier
Kwanazi,
told this court, that
if
after
that's
the
the first line,
completion
because he just says J.D.
of the pointing
Kwanazi.
out
If he had said
of the
Brigadier
scene,
J.D. Kwanazi,
and the
then
points,
in the next line say
the
acting
notes
police chief,
were
the
read
way that
to
he has
you,
done, would you still have the same concern?
and
that he
they
has?
were interpreted once again.
Which lines are those,
Let's not
So
worry
that
about
same
interpretation,
signature
because you said there was
area
no
the chair is
interpretation.
discussing with you.
Yilokhu-ke uKenya Hadebe
So,
akutshela-ke
you've got
le
just
nkantolo
J.D. Kwanazi.
ukuthi-ke impela-ke emuva kokuthi
You see where-
sekuqediwe-ke lokho ayebhale phansi wakufundelwa
I
futhi-ke
don't know
kwase
how
kuyahunyushwa
people sign
asikhohlweke leyo
in
kumusha
municipalities
ngoba-ke
or
ushilo
comes
ukuthi
with
sasingekho isidingo salokho nanjengoba-ke
If
nanizwana
he had
ngenkulumo.
said, if
Now,
at the
these are
bottom there, if
notes
he had
that
said
were made
Brigadier
at
J.D.
the
Kwanazi, so
time
he
at
describes
which you were
himself,
pointing out,
title
really
and
pointing
name,
out there, and then he
Brigadier
was
J.D.
busy
Kwanazi,
making
and then in the next
manje
line.
ngokusho kwakhe ukuthi
Then
lo
says
bhala-ke noma
acting
lama-notes-ke ama-notes noma-ke ubhala kwenze
deputy.
ngalesi khathi ngaso athi wena-ke wawuqhubeka lokho njalo-ke ukhomba-ke ukhomba iy'ndawo thizeni lapho
Would that
Yena-ke
still have
ngaleso
raised the
sikhathi
same
ubhala
concerns
phansi.
that you're
These are
raising?
the notes that are being referred to
It
here.
would have, but it would,
Uma-ke
perhaps it
esho
would have been a
lokhu
bit
kakusho
different in the
lapho
sense
paragraph
that,
12 ukhuluma ngalokho-ke.
remember,
Now-
and I think that the previous witnesses testified on this.
You have been
You
here,
have
and this
the rank
information.
of brigadier,
the
you know,
state
and then
also
you've got
took you
a
through.
post designation in terms of your organizational
And
structures.
in their
You know, now, if you had
cross-examination
said
on this
Brigadier
information.
Mkhwanazi,
Now, we've been here throughout
and then said
trial, you had the
underneath,
testimony
he
of-
called himself
of
Brigadier
Mr.
Mkhwanazi,
Hadebe.
and then underneath
From its beginning to
indicated
the
that
end,
is acting
there were
deputy chief of
exhibits
police.
that were also
Again, it
introduced
still
as such.
creates the
Are
challenge
you
from
aware
an
of
HR point
any
of view
notes
to say exactly who
that
is signed,
were
but it could be,
introduced by
it
the
could
state
easily
through
be,
Mr. Hadebe relating to
dealt with by
what
what we are
has just
raising.
been read?
Say that, okay, fine, it's Brigadier
Ubukhona-ke ngaso
Mkhwanazi,
sonke
but it's
isikhathi
So the person was actually signed
ubufakazi
is
bakhe
the acting,
uKenneth Hadebe
as
suke
opposed
ekuqaleni
to
kuyofica-ke
both.
ekugcineni-ke ngaba khona yini ama-notes owaziyo umbuso-ke
understand your point if
owadlulisile
he
enkantolo
had
ukuthi-ke
signed as
nawa-ke
though,
lama-notes-ke
acting
akhuluma ngawo
deputy
uKenneth Hadebe ngicela
municipal
wadlulisele
police
enkantolo
chief
ukuthi
and
inkantolo iwabona
director of
njengobufakazi.
specialized services.
No.
But here it's clear that he's referring to only one role, and the brigadier
Furthermore,
is the rank he holds. That is the chairperson role.
This, my lord, we
That
really
it
don't
is
want
the
to
rank,
interrupt
whereas
counsel.
the role is that of acting deputy
We submit,
municipal
my lord,
police
that
commissioner. Now, if
cross-examination,
he had
examination
said
must be
acting
based
deputy
on correct
municipal
facts.
police commissioner
And
slash
we have referred, my
director
lord,
of specialized
to
services,
the relevant
then
passage
that would be
yesterday.
different because those are
And
two
when we
different roles.
cross-examined
But his rank does not
Cecilia,
change whether
where
he's acting in one role or
reference is
the
made
other.
to the
He
notes.
remains brigadier.
Now,
I get the point.
That's really
put
the
this-
chessboard.
I get the point. If you put it that way, I get the
proposition,
point that you're raising. Yeah, thank you.
as
So
to
I
whether
failed in putting across my.
the accused is aware
I get the point. Thank you, Commissioner.
of notes that were
So
introduced
that is the issue that jumped out,
by
but
the state
nonetheless,
through
the contents of the
cannot
letter
be,
themselves,
correct, my lord,
you know,
based on the
the author of the letter says
relevant
that there
passages
is a
that we have referred
memorandum
to,
of understanding
to
that
the
is
court.
signed with CAT VIP.
This is the court, madam.
Now, there is no memorandum of understanding.
This document
between the municipality and
was read
CAT VIP.
into record
You know, when I
by
looked
Mr.
at
Hadebe. This is what he told this court.
There is
That
no sign.
after the conclusion of the pointing out
there is no
of the scene
memorandum
or
that has
points,
been entered into.
the notes,
So
which
this
notes are those?
is
Those notes
grossly
which were
dishonest in
made
my
when
view.
allegedly that pointing out
To
was
say
being
that there is a
made.
memorandum
Then
when such is
were
not.
read to
does
the
not
person who
exist, but that
pointed
there is a
out
draft.
and they were
A draft is
interpreted.
that, it's just simply that, it's a
Now,
draft.
this is a
There is
very
no
logical
actual
question.
memorandum that
Mr.
existed.
Hadebe was
But
here.
This letter,
He read this
you know,
passage into record.
makes a representation.
Now the question
is a memorandum of
is
understanding
Mr. Sibia
between
aware of any notes
This company
that
and
were
the municipality.
placed on record
Where such
as
stuff was
exhibits? It has been the norm in the trial that each and everything gets to be
Thank you, Mr. Ngiza.
put on record as an exhibit.
You then make
Is he
a
aware
concluding
of
remark at the
any
end of
notes
paragraph
that were
39.1.
made when he was pointing
that-
out
this representation or this was intended
as
to
an
close
exhibit.
this arrangement with some form
Then
of
his answer
regulatory
is no.
standard
So where is the
standing where
wrong
there
there?
was none. Is that correct?
Yes.
Thank you.
And that is basically because he did not have the authority.
Where's the wrong there? I don't know who to ask, my lord. But that's a standing question.
Something else in that first
I
paragraph.
think Council now has
is
just
significant.
introduced a
He
qualification
says
that were made during the
letter
pointing
said
out.
to confirm
That is not
that
what
the EMPD,
was put
and
to
this is the part
to
that I
Mr.
just wanted to
Sibia
confirm
when we
the
made an
correctness of.
objection.
Under the command of Acting Deputy Municipal Police Commissioner. So as
This
Acting
paragraph 12
Deputy Municipal
refers to notes that were made
Police Commissioner,
during the pointing out.
the
when Mr. Sibia
EMPD
was
fall under
pointing
his
out.
command.
So, Mr. Sibia, you are saying there were no
The
such
EMPD
notes.
falls under
Man,
the command
lana
of
ke
the
kubhaliwe
chief.
lana ke ku-12
Even if it was not
kukhulunywa ke
acting.
ngokwabhalwa phansi
Even if it was not acting.
nkathi kukhonjwa wena ke uyasho
Structurally,
ukuthi
the
awungalwazi
EMPD had various
ngokubhala phansi
divisions.
ama-notes anjalo.
So the deputy municipal police commissioner
ngoba nje
is the
uhadebe
head of a
ngawakhiphanga
division.
nala ecourt ingoba
Not the head
engekho
of the
akaze
department.
zebhalele
He's the head of the division.
wayethatha
I
nje
can't
mina ngikhombe
say
ethi angikhombe lapha
the divisional head
ngikhombe
employee
lathi angikhombe
relations.
khona bese kulona
You know,
umnyaka
human resources is under
The
my
fact that,
command.
because they were not
You know, I'm just the head of a unit.
produced or by
So
Hadebe
it
here in
was-
court, or
it-
he did
it
not
wasn't correct for
give
him
them
to say that
to the court
EMPD
or handed
under
him
his
over to the
command.
court.
So
It
it
means
was a
that there
misrepresentation.
were
It
no
was a
such notes.
misrepresentation.
Because what happened was that Hadebe would just point me at
That
a
is the
particular
first
spot
misrepresentation right at
and
the-
instruct
just
me
at
to
the
point
blocks.
there and then
But then
tell the
another
other person to take
misrepresentation is
a
made.
picture of me.
The misrepresentation about an endless working relationship.
I don't want to
Firstly, there is
put
no
you
working
in the
relationship,
thick
let
of
alone an
things.
endless one.
Would you say,
You know, he
in this
had
regard,
his working relationship, not the municipality, not the EMPD.
that Mr.
What
Hadebe
became
took
clear
the
in
court
terms
to
of
his
the investigation is
confidence
that indeed there was
about
some
what he
working
wrote here in the
relationship,
absence of those notes?
but it's not a working relationship of the municipality with CAT VIP. It is not the working relationship of EMPD with CAT VIP. It is a working relationship that he has constructed outside of the regulatory framework, outside of
I
the
don't know
policies of the
whether the
municipality.
opinion of this
Outside of
witness is
legislation,
relevant. It's
He constructed that relationship.
an opinion is being
And hence,
elicited
perhaps,
from
he
a
terms
witness
it
which we
as an
submit is
endless working
relevant.
relationship.
It's a
Because
matter
there's
for
every intention
argument
of not
that
separating
council
from
can
CAT VIP.
advance.
Whereas the municipality enters into all forms of relationships,
You've
but
already
they're
commented.
defined.
Thank you.
They're defined. There's a process to enter into a relationship, and there is
Why
a
not?
period
Wayefuna iqiniso yini kulokhu akubhale
of a
lapho?
relationship.
wayengakhulumi iqiniso Hadebe
No, he was not telling the truth.
ngoba lento athi wayenza akaze
Mr.
ze
Ngiza,
Because what he claims to have done, he never did it.
fana nale ngale
consumption
yokuthi
again
ethi
was this
zi-5
intended?
May ethi
I
wabuye
see there's no
wamfundela akaze ze
specific
yenza lento leyo.
addressee.
Same applies with
It
what's
says
contained on the
to
other
whom
side
it
where
may
he said
That is
on the
another
5th of May, and then he
worrying
read
factor,
to me. He never did that.
Mr. Commissioner.
Thank you.
Mr. Chair.
And he
Because
further says in
When
paragraph
addressing
12,
official
subparagraph 1,
you
he's
address
asking
the
you,
letter
or
to
he
a
said he asked you,
specific individual or
on
entity.
whether we are satisfied
This is
about
addressed to
that
whom
which
it may
you pointed
concern.
out,
So the bearer
and
of this letter,
said
the bearer of this letter
That-
can then
that was
claim
noted
that I
down
am the
correctly.
whom it may concern.
Bese uyaqhubeka ke
And
lana
therefore,
yinto athi ke
note
yena
that I have this relationship with this
weneme noma
state entity.
kulisekile yini ke
and my actions
ngalokho
are covered
okukhombile nokuthi
under
futhi ke kubhalwe phansi ngendlela ekuyiyona noma efanelekile.
It's just too
Ngoba
wide.
ngishilo ukuthi
and
lo mbuzo
it's-
lo Hadebe akaze sengibuze
It has potential to create serious
As
problems.
I've already
We
said,
don't know,
that
even up
Hadebe
to
never
today,
asked me this question.
who actually
Thank you, Mr.
then
Sibiya.
had this letter and what did they do with it.
Let's go to quickly
I have not
this.
come
I
across
think this
any
would be our last
information
item on
that says the
agenda.
people that got this letter, you know,
Normally
if it
that
was
is
CAT
item number
VIP people,
17.
what did they
I
do
don't know
with
why
this?
it's item number 17 on the agenda, but
And
all
that's a
the
scary
meeting
thought
I
that
would
a
take
letter
to
of the
say
municipality
the last item on the agenda
be in the
is item number
hands
17.
of
I don't know
individuals,
what that means.
so
But
that
this
even if they
is
get into a
our
roadblock,
last item on the agenda. Do you
even if they
understand?
get into all sorts of other situations, they will not be charged. We'll just simply say, but we
Thank you.
are in a relationship with the MPD.
Now,
You can't touch us.
It is, when you say they, it is these vehicles So this letter lists vehicles.
In the Ronia
So
form,
if
Exhibit
any one of
GG.
these vehicles got into a situation such as you're describing, they would show this and say, I am that vehicle. I'm
I'm this vehicle, and therefore,
working for the municipality.
I'm
In
clothed
paragraph
with
11.
this, what you call protection, if you want to call it, but effectively, because I've got this relationship and therefore I work with EMPD.
In paragraph
I do this
11.
with EMPD. So who are you therefore to obstruct me? It will be as if you're obstructing
Mr. Hadebe noted
police.
that
Let us
the
adjourn
time
this
at
matter.
which you returned from the scene was exactly 1:30 midday. And he also states the kilometer reading there.
Lana ke uyasho ke noma ubhalile phansi uKenya Hadebe ukuthi ke isikhathi enabuya ngaso ke la enaniye khona ke athi ke indawo oyokhomba kuyona kwakungo 1:30 kusemini wasebhala ke ukuthi ke imoto ke noma ama kilometer motor ayethini.
cases get
Did she
investigated by
explain
police.
anything to you?
When we met in the morning, because I went directly, instead of going to which my would office, include Brigadier Mkhwanazi.
I went directly to
So they requested that instead of proceeding,
in the morning
Early in the
as I was
morning.
instructed to facilitate.
because
So I would not
I
have
went
facilitated
directly,
this
instead of going to
which
my
would
office,
include
Brigadier
and I went directly to
So they requested that instead of proceeding,
in the morning
Early
as
in
the
the-
content of the
because
conversation.
I went directly, instead of going to
which
my
would
office,
include
Brigadier
I went directly to
So they requested that instead of proceeding,
in the morning
Early
as
in
the
the-
content
what I'm
of
gonna
the
say, because
conversation.
I went directly, instead of going to
which
my
would
office,
include
Brigadier
I went directly to
So they requested that instead of proceeding,
in the morning
Early in the-
andifuni ukuthi omashazi mina yenza le leto. Xolani, this lady has shouted at me. I don't want to be further shouted at. Do the letter. I'm saying it was a norm because every instance where something has to happen in the municipality and HR must do something, if you have an issue, you will be told that I don't want to be shouted at by Mashas.
All right, thank you.
Thank you, Commissioner. Mr. Mnisa, you are then at paragraph 51 of your witness statement, where you detail, you make certain remarks or conclusions on this intervention. Can I invite you to share those with the Commission, please?
Yes. I make this remark here, Commissioners, because this was not the first time that we have a situation where there's an extension of a suspension, and it certainly was not the last. There is a gentleman that we had suspended who was at a divisional head level. That person was suspended in May 2023. An investigation of sorts was being conducted in the department. At the end of the suspension period in August 2023, Klasheka instructed that a letter be composed to extend the suspension. And we've got a number of other instances where suspensions in the municipality would be extended, either because the investigation is still underway, or at times the disciplinary proceedings have commenced but have not been concluded, and then a view is taken that indeed the suspensions be extended. So the manner in which this was handled was out of kilter with how others were handled.
And so you're saying in that example in paragraph 51 that even in the context of a suspended employee where the allegations against him were at that stage still preliminary, an extension of the suspension was granted and the employee was directed to continue staying away from the office?
Yes.
Yes. Viewed as against the case of Brigadier Mkhwanazi, where the formal internal investigation was completed and a docket was already submitted to your office, and yet the extension of the suspension was not granted.
Was not granted.
Thank you.
And remember, the point of the matter is the non-extension, so to speak, had nothing to do with the actual facts of the case.
Can I then allow you to conclude on this subject with what is stated at paragraph 52, my apologies.
Yeah, I don't know whether I'm allowed to just correct the statement.
You're welcome, please.
Yeah, I think, commissioners, I think my use of the word endangered witnesses is a bit strong, and I would not be in a position to actually support that. But rather, I would rather say that this intervention potentially compromised witnesses. Because that is one of the key issues that you don't want to see happening with regards to a discipline management process, that your witnesses get compromised as a result of the active presence of the accused employee in the institution. So this potentially compromised witnesses of the municipality, the documents that would have relied upon at the hearing, and even the integrity of the disciplinary process itself.
Those were the very reasons that you put for suspension.
For the suspension in the very
decision.
first place. In my view, those reasons still existed. Not only my view, but also the view of the department. Those very reasons still existed at that point.
Yes.
And would you then agree, Mr. Nziza, that the very risk you were attempting to prevent, the risks identified in paragraph 52, the efforts to prevent them through the use of the suspension were undermined by the upliftment of the suspension?
Yes, ma'am.
Thank you. Thank you. Can I then ask you to turn to paragraph 53 and detail the events of the 24th of May? Paragraph 53.
So after I had met with Ms. Lasheka at the office, and we had agreed that indeed we will do the resumption of duty letter. I mean, to do such letters, there's a template, so you just craft it. It's a quick thing. I had to leave her office and go to what is called the administrative precinct. The office would be, if it's on this side, the administrative precinct would be where council is sitting, and then the government precinct would be where you are sitting as commissioners. So her office is this side, left, then straight. So I had to go to the administrative precinct, where the city manager's office is located. There is a huge parking lot in between. There are two parking lots actually. So as I was walking towards the administrative precinct, I ran into Brigadier Mkwanas in full uniform, at the parking lot. We greeted each other, and then he indicated, as per what is on paragraph 54, tried to engage me to say, no, Olani, these guys signed documents that they are now accusing me of, so like, no, these guys have signed, but they want to fire me for what they've already signed. So I avoided the engagement. I was like, okay, yeah, hey, now into Zakon. I didn't want to engage. Remember, I was aware of what is contained in the investigation report, and as a matter of principle, I do not engage with employees that are the subject of either a disciplinary hearing or investigation on the contents of that particular process. So I was like, no, just downplayed it, and he was on his way to see Kashega at the time. And I just politely sort of disconnected and went on my way, and I didn't want to engage him on the substance of the matter.
Please proceed to paragraph 55.
Now you have a situation on the 24th where Mkwanas is back. I engaged the chief of police to say, okay, fine, now what? What is the plan in your department in terms of how do you handle this situation? He indicated that, no, it's fine, he's back, but I've redeployed him. I don't want him in the unit where all of these things were happening. I've redeployed him into bylaw enforcement because that position was vacant at the time. And of course, the basis upon which he wanted to redeploy talks to what I have raised even on paragraph 52, ensuring the integrity of the disciplinary process, is kept. So that was his concern. And I later learned, not on the 24th of May, but sometime in June, that another intervention had come about to direct that Mkhwanazi go back to his substantive position of Director Specialized Services.
Thank you. And therefore that the efforts of Chief Mapiere then to try and keep Brigadier Mkhwanazi outside of his original station were unsuccessful.
Yeah, they were unsuccessful, because at the end of the day, the municipal manager, gets involved. She gets involved, even though the letter itself that actually directed that Mkhwanazi must go back was from Tlashega. You ask yourself even how does Tlashega get to know that Mkhwanazi is deployed to another unit instead of his former station? So there was just this pressure that was put on Chief Mapiere that you are going to do this thing our way and not the municipality's way.
Mr. Ngiza, with reference to paragraph 56, at some point in May of 2023, it becomes clear to you that the imminent arrests are not so imminent. Please then tell the Commission what steps you took thereafter.
Now, this is after the 24th of May. I engaged with the chief, I engaged with Spies and Erasmus, and a view is then taken because for me, my processes still need to run. I have no instruction from anyone that says the process that I've approved in April should not run. So I then engage them, and the view is taken that I must now constitute the disciplinary tribunal. My 3 months is running short. We are already left with less than 1.5 months. So we then took that view that indeed I must now process what you call the disciplinary tribunal, let alone the issues of the suspension, because the suspension, was dealt with. It is for me, honestly, it was a closed chapter. I was not going to concern myself with the suspension. I need to deal with the disciplinary tribunal at this point.
And if I take you back to paragraph 56, in addition to your concern that IPID was not going to arrest anyone anytime soon, you detail there a further concern that you had about the dynamic in the work environment, I would say.
Yes.
Please.
I mean, it was clear how the matter of the suspension was handled, that Mkhwanazi has been protected by Tlashega and Mashazi at that point. It was clear to me that, in respect of how the suspension was handled, that was the situation. But I still needed to ensure that my process is carried through.
To your knowledge, Mr. Ngisa, did the city manager and or Ms. Tlashega become aware of the IPID investigations? Were they, as far as you know, did they become aware of that at the time that you were given the instruction to withdraw the suspension or not to extend the suspension?
The IPID investigations.
Yeah.
My understanding at the time is that Chief Mapiere had informed the city manager that there was an IPID investigation into Mr. Mkhwanazi's activities. But the extent of that at this point, because you see, there is a lot that happens post-May. At this point, the extent of her knowledge, I would not be able to say at this time in May.
Thank you.
Thank you, Commissioner. Mr. Ngisa, we're then at paragraph 57, where you've explained to the Commission your decision to move ahead with constituting the disciplinary tribunal. With reference to that, your second sentence in paragraph 57, please just explain what factors motivated the appointment of external lawyers there.
As I had indicated, in terms of how the collective agreement is structured on the default position, now, when I look at the default position of appointing a person to preside that is a level or 2 levels higher than the position, it meant that I would have to appoint a divisional head or an HOD. Now, there were very few divisional heads and even less HODs that were trained to be presiding officers or even prosecutors. So already we've got a very limited scope, you know. Secondly, experience has been proven that in that very limited scope, people are very busy. They simply do not have time, you know, and that had been reported to the municipality on numerous occasions, that it would always be a challenge to get a divisional head to reserve time and not deal, for instance, one of the people that would have been appropriate for the appointment would be a divisional head in the water services department. And you're having all these challenges with water services, and then you expect this guy to go and sit in a disciplinary hearing for a week. It's just impossible in the municipality. That is a consideration that talks to the complexity of the situation, but also the complexity of the situation in terms of the merits of the case. You know, where such that we are dealing with matters or charges that would involve issues of gross dishonesty. A person that would have to sit at such a hearing must have an acute understanding of the policy regime that governs these processes, you know, that were involved here. And then also not only the policy regime, but also these legislative issues that would come into play when we are discussing, or rather when we are busy prosecuting a case of this particular nature. So those complexities play a fundamental role in terms of a determination that must be made on who to appoint within the limited scope. So then it became clear to us that we would have to get external legal services for us to be able to deal with this matter, as well as, of course, the potential, given, you know, the totality of what was at our disposal in terms of the information on issues that Brigadier Mkwanazi was implicated in, besides just the blue scandals, blue light scandal, the blue light scandal. That will be a nice one. So, besides the blue light scandal, so you then have to look at.
Maybe it's there somewhere.
No. So you'll also have to look at. It's only responsible for a person who's head of a labor relations environment where you've got more than 20,000 employees to make decisions that would not only benefit your process but also benefit those that are connected to your process. The potential for victimization or even harassment of the very same people that will be the disciplinary procedure, disciplinary tribunal committee. You know, there is that potential that we must look into. And given what we had in terms of the activities of this individual and those that are connected to him, it would not have been a rational decision for me to insist on having internal people dealing with this matter, quite honestly. Hence, we then took a view to appoint the external legal representatives.
Thank you. Mr. Can I ask you to turn to page 290 of your annexed bundle?
Yes.
You there?
I'm there.
Thank you. You set out in paragraph 58.1 one of the appointments that you made.
Yes.
Yes. So can I ask you to take the commission through that paragraph with reference to this document?
Yeah, I appointed Madlanga Attorneys, which is a firm of attorneys that is on the panel of attorneys of the municipality. And in the appointment, I mandated them to brief Advocate Sandile Sibisi to prosecute Brigadier Mukhanazi.
Is it necessary to mention the names? Is it not sufficient to just say a firm of attorneys and counsel?
Fair enough, we can do that, Commissioner. Mr. Ngiza, in the course of giving evidence as it relates to the two appointments that you made, are you able to do that without direct reference to the individuals involved?
Sure.
Thank you so much.
So I appointed a firm of attorneys that is in the panel, and I requested them to brief an advocate, I think he's in the Johannesburg bar, to prosecute the matter and to prepare the charge sheet.
Can I then ask you to go to Annexure P in 9, which is on page 291 of your Annexure bundle? Okay. And
Similarly, in line with the determinations that were made in respect of the appointment of the prosecution team, I then appointed a firm of attorneys that is also on the panel of attorneys of the municipality, and I requested them to brief an advocate who would then be the presiding officer in the Disciplinary Tribunal.
And having constituted your tribunal now through these two appointments, please explain from paragraph 59 the subsequent developments following those appointments.
Just as a matter of note, commissioners, in both appointment letters, you will note that there is a line that says, please note that the internal official responsible to this matter is Mr. Ngiza, with the landline telephone number in both instances. So then ordinarily, a matter would be allocated to a labor relations officer or a labor relations manager. But in this instance, like I had said initially, I wanted the matter to reside with me in my office. So I then communicated with the firm of attorneys and directed them to say that this is a matter that is in the EMPD, and therefore they would need to be in consultation with the EMPD in order for them to get, as much as there is a docket, but also to get witnesses that will be in a position to testify on the matters that were contained in the docket, and which would also assist them in the process of drafting the charge sheet. So yes, I indicated that. And then I don't know whether I should just continue with how the entire process.
Please
unfolded.
proceed. I'll ask Mr. Ngiza that when you give the identities of the individuals involved in preparing the charge sheet, you'll omit the names of those engaged by the law firm. Thank you.
So indeed, there were numerous individuals from the department who then got involved with the preparation of the charge sheet. Of course, given the nature of the allegations, the process itself became a bit more detailed than what one had initially anticipated. There were several engagements that were held, and I was involved. Persons from the firm of attorneys were involved, and then the investigator that compiled the investigation report, which is Erasmus, and then I involved at this stage. It's when I then decided that I would also need to involve the manager in my office that deals with discipline processes, because now it is at a stage where the actual facilitation of the disciplinary tribunal must take place. And in most cases, I would not have sufficient time to be involved directly with the actual disciplinary hearing. Yeah.
Yes, please proceed to paragraph 61.
The charge sheet was at a later stage amended in order to include additional charges. This would have been around about the 19th of June, when there was an indication, 19th, 20th June, when there was an indication that indeed the charge sheet did not include matters that pertained to the operational plan. And therefore the charge sheet was then amended, and eventually the final charge sheet was supplied by the firm of attorneys on the 20th June 2023.
And that charge sheet is annexure PN10, which is found on page 292 of your annexure bundle.
Yes, ma'am, it is.
With reference then to the charge sheet, Mr. Ngiza, you've indicated that it contained 6 charges.
Yes, ma'am.
Correct. The heading at the top of page 293. Could you please read that text highlighted in bold at the top of page 293?
Charges: failure to conduct yourself honestly and thereby infringing the disciplinary procedure collective agreement.
And you confirm that's the document we went through this morning?
Yes.
The DPCA, thank you.
Yeah.
Mr. Mnza, I won't ask you to read the entirety of the charges into the record. We've attached them for the attention of the attention of my apologies. Okay. I won't ask you to read the entirety of the charges into the record. We've attached them for the convenience of the Commission, for the benefit of the Commission. What I will ask you to do is to take the Commission through, sort of a summary of a charge as it's set out there.
Thank you, Council. Commissioners, the charges that are set out relate first and foremost to the memorandum that we dealt with of the 16th of October 2021 that spoke about EMPD being under the command of the Brigadier and or the endless working relationship, where indeed we were alleging that even the crafting of that particular memorandum amounts to gross dishonesty on the part of the Brigadier. And then you have the charge number 2 basically speaks to the issue of the memoranda of agreement, the 2 memoranda of agreement between, purportedly between the EMPD and CATS Security Services, as well as Medicare 24, emergency services. Again, the issue here is about gross dishonesty because the allegation is that the Brigadier had made it seem as if there is indeed a memorandum of agreement that was entered into between the parties. And he placed reliance on that order that caused other people to place reliance on that submission. And then number 3 effectively deals with the registration of the 4 vehicles onto the municipality's name, which we dealt with in terms of the processes that he engaged with Christine and them, and got those vehicles registered under the municipality. And again, the allegation is that this amounts to gross dishonesty and abuse of the resources of the municipality, as well as his position of authority. The fourth charge is about the implications of that memorandum that was issued. That effectively means that people can impersonate police officers, because they would have a memorandum on the letterhead of the municipality that states that these people are having this working relationship with the municipality, and therefore, as people that are working with the municipality on these specific issues, those people can then be taken to be members of the Metro Police Department, and indeed, by extension, those people can then be taken to be allowed to use blue lights because of the impersonation of a law enforcement official. Again, the allegation is that indeed this amounted to abuse of his position and gross dishonesty, and as well as abuse of the resources of the municipality. And then the fifth charge relates to the issue of the donation in terms of the report that he had submitted to Commissioner Spies. In the report that he had submitted, he speaks to, I think it's the report that contains the title cartels. That report, he speaks to a donation that he had solicited and received to the value of 200,000 rands. So this, again, is about the non-observance of your council processes, your council policy and the likes. Again, this amounted to gross dishonesty, abuse of the resources, insubordination, and abuse of the position of authority. And then the last charge is the one that is now talking to the operational plan. And the argument here is that the operational plan that was submitted by Brigadier Mkhwanazi in February 2023, pertaining to the state of the city address, was altered and therefore constituted a fraudulent document that he had submitted.
2022.
2022. Yes, state of the city of 2022. Thank you, sir.
Thank you.
Yeah. So those, in essence, were the charges, the 6 charges.
Thank you. And Mr. Mniza, if I might just turn your attention, for example, to charge 6 on page 294. The last sentence there reads, your conduct amounted to a violation of clauses 1.1, 1.2.3, 1.2.4, and 1.2.5 of the DPCA.
Yes.
Do you have, are you able to give the Commission a sense of what those clauses in the DPCA relate to?
Yes, Commissioners, the DPCA, which is, I don't know what is it marked as.
15.
15.
B. 15B.
Right at the end of the DPCA, I think if you look at the numbers at the bottom where there's initials, page 24. The DPCA has got an annexure. After the collective agreement has outlined all the procedures, then it has an annexure.
Just to assist you, Mr. Ngiza, so we're all on the same page, you've directed us then to 15B, that's
Yes.
Circular 1 of 2018, the DPCA. You've asked the Commission to turn to Annexure A on page 24. Is that right?
Yes.
Thank you.
Exactly.
Please continue.
So, whenever you draft a charge sheet, and this commissioners have experienced not only in Ekurhuleni but in other municipalities where I've been called upon to assist with discipline management, you have to, in the charge, put, having outlined what is the charge, then a prosecutor would ordinarily put which clauses of the standard of conduct the employee has violated. And in labor relations nomenclature, this would be what rule has been broken. So the first one, and you will see that in almost all the charges, there is a consistency, 1.1, that there's an expectation to comply in every respect with the conditions of employment and collective agreements and any related regulation, policy and practice of the municipality, and to refrain from any conduct which would give just cause for discipline. So that is a standard that the prosecutors had put, that this, what Brigadier Mkonas had done, give rise to, or rather give rise to a just cause for discipline. And then 1.2.3, perform their tasks and job responsibilities diligently, carefully, and to the best of their ability. So effectively, the charge also talks to that. All these charges say, in what the brigadier had done, there was no adherence to a diligent performance of one's tasks. 1.2.4, obey all lawful and reasonable instructions given by a person having the authority to do so. Clearly, if a person is going to go and do things that are outside, the policy framework, that is a person who is not obeying instructions. 1.2.5, conduct themselves with honesty and integrity. So that is what effectively the prosecutor had crafted as a case of the municipality against Brigadier Mkonas, that his actions are in contravention of the disciplinary procedure collective agreement in relation to that standard of conduct.
And Mr. Ngqiza, if we stay in Annexure PN10, which is the charge sheet, if we turn to the last page of the annexure.
Sorry, before we go to PN10, the documents you have marked 15A and 15B, should they go into Annexure PN4? Where exactly are they supposed to go in our bundles?
Under Annexure 15, Commissioner.
PN15?
Correct.
Oh.
Correct.
Yes, ma'am.
On page 296,
96.
Mr. Ngqiza, that is the last page of Brigadier Mkonas' charge sheet. There's a paragraph there drawing attention to the engagement of a prosecutor to initiate the proceedings. Do you see that?
Yes, ma'am.
Thank you. At the bottom of the page, bottom right corner,
Yes.
where it says confirm receipt,
Yes, ma'am.
what purpose or what utility does that section of the charge sheet serve? What is ordinarily meant to be recorded there?
When you serve an employee with a charge, you need to certify that indeed this person has been served. And the best way to certify that the person has been served is for the person to acknowledge your receipt of the charge sheet. So what would happen is, when you serve, you would have two documents. You would have the charge sheet and a copy. Then you would give the employee, and then the employee must sign on the copy that indeed I have received this charge sheet, so that even when you go to the actual disciplinary hearing, the presiding officer can satisfy himself that there's proof of service of on the employee. That is the standard.
And was there in fact proof of service on the employee? Was this charge sheet served?
No, the charge sheet was not served.
No. Can I then invite you to paragraph 63 of your witness statement?
So, on the 20th of June, Commissioners, the final charge sheet that all the parties involved were satisfied with, and I'm saying all the parties involved, critically for me, the case in a disciplinary inquiry must be made out by the department. So it's important for me that the department is satisfied with the charge sheet, because it is the department who are the witnesses, it's the department who are the experts on the policies, on the procedures that must be followed in the department. So when I say the parties, critically it is the department that had also confirmed that indeed they were satisfied with the charge sheet. Then I instructed Mr. Zitsamba, I instructed my manager to then process the serving of the charge sheet as per the norm in my office. So, the manager then came back. I think the final charge sheet was emailed to my office. It was just before 1. It was just before 1. Then he had called, or that he came back to me and reported that he had called Brigadier Mkwanazi and indicated that he wants to make arrangements for the service of the charge sheet on him. However, Brigadier Mkwanazi had informed him that he is not going to come. He's not going to meet with him, and he's not going to accept the charge sheet. And the reason why he was not going to do that was because he, Brigadier Mkwanazi, had instructions from Dr. Mashazi, the city manager, as well as Ms. Trasheka, the HODHR, not to accept the charge sheet because that case is not going to fly. Not only did the manager indicate that conversation with Brigadier Mkwanazi, but there was a further conversation that he had immediately after having spoken to Brigadier Mkwanazi. Indicates that he was then called by the personal assistant of Ms. Trasheka, who informed him that Ms. Trasheka has instructed that he must not even attempt to serve that charge sheet on Brigadier Mkwanazi. So that's why the charge sheet was not
never
served.
served. And Mr. Ngiza, in your engagements with the HR manager responsible for the service of the charge sheet, did he ever relate to you the basis for that intervention? So on what authority or on what basis did the city manager and Ms. Trasheka direct that the charge sheet should not be served, or that the brigadier should not collect the charge sheet?
Well, he did not have a basis. He did not relay a basis because he just indicated that he was instructed not to serve, and there was no reason provided to him. Instead, he was miffed. He was like, but what is this now? Since when are these individuals part of our process? This is an ER process. You have appointed a disciplinary tribunal. Now all of a sudden we get calls that we must not do our work
And what did you say to him in response to that? So after he updated you about his challenges with serving the charge sheet, what was your response to him?
Given my experience the previous month regarding the non-extension of the suspension, you know, I had a sense that, yeah, something is afoot here. So I requested him to just simply record in an email what has happened and to inform the prosecutor.
And all of this happened without Mr. Sheka speaking with you? Did she not speak to you at all?
No one spoke to me. No call from Mr. Sheka, no engagements with the city manager.
Yes.
This was just relayed to my subordinate.
Thank you. Thank you.
Thank you.
Incurred costs employing 2 advocates and a firm of attorneys to prepare the charge sheet and to act as a prosecutor and a chairperson of the disciplinary.
Yes, Commissioner, I will get to the cost factor because indeed costs were incurred, but not for the presiding officer. The presiding officer, as much as an instruction was issued, there is no work that the presiding officer has done. The people that would have done work is the prosecution team to prepare the charge sheet and the likes, and the consultations that they had with the potential witnesses of the municipality.
So all that money was wasted for nothing.
Effectively, this meant that the money becomes wasted. And there's going to be a discussion about that particular aspect. But I want to indicate that indeed the money became a wasted money because of the intervention.
Your policies and procedures, including the collective agreement, do they give the HOD of Human Resources the power or standing to give this kind of instruction?
Nope, not at all. Like I explained the delegations matrix before, the only person that was delegated in the municipality as of that time to institute disciplinary tribunals is the divisional head employee relations, no one else. The municipal manager would only institute a disciplinary tribunal in respect of a council resolution to discipline an HOD. And that is as per the disciplinary regulations for senior managers. The regulations stipulate that if council has taken a view that there must be disciplinary process, then the municipal manager, by way of council resolution, must appoint. But in respect of everybody else, especially people that are governed by the DPCA, the delegation resided with the divisional head employee relations and no one else.
Thank you.
Thank you, Commissioner. You make some remarks in paragraph 67 of your witness statement. Can I ask you to briefly share those with the Commission?
This Commissioners, is in line with my response that I've just given now to Commissioner Baloyi. And this is borne out by a process that the municipality went through, a very painstaking process that the municipality went through between, I think it started around 2016, that case, until around about 2022. This LAC judgment that I speak to here, where again, unfortunately, it's in the EMPD, you know. It seemed that this was a problem child department. It's in the EMPD when there was an attempt by the then acting HOD-HR, in a recruitment process where there is a policy framework, and the policy framework provided that if you are going to do some form of exceptional circumstances recruitment. I'll say exceptional circumstances recruitment because there need to be a deviation from your recruitment and selection policy. That policy then gave the authority to have those exceptional circumstances processes to be done by the divisional head workplace, it was called workforce capacity management. And that divisional head had that authority, no one else. The policy is clear. Now in this case, you had a situation wherein the acting HOD-HR intervened and processed an exceptional circumstances recruitment process. The matter went on. Unfortunately, it was just before the elections in 2016, and then a new, administration came in, but then Dr. Mashaz was the acting city manager. She became the acting city manager, and she did not approve the appointment of the person. We litigated that matter, went to arbitration. The arbitrator said, but if the municipal manager and the HOD-HR have taken a decision, the DH's authority stems from the city manager and the HOD-HR. Therefore, he surmised that it is proper. If these ones have taken the decision, they've effectively overruled the DH. We went on review. The Labour Court agreed with the Commissioner that it was a reasonable award. We went to the LAC. The LAC said, no, it's not. The principle of legality vitiates that thinking because you have a policy position that says this person and no one else is delegated to do this function. So you can't have another functionary in the municipality taking over that function. So from that perspective, even though the HOD-HR was my supervisor, the function, the authority to do the function resided in the DH position. So the supervisor then does not have the authority to override the decision of the divisional head.
Did you show them the judgment, Mr. Ms.?
They have it. I mean, we
No, no, I'm talking about at the time when they intervened in June 2023.
No, I didn't. Quite honestly,
Because your point is that they had no power to do what they did, and you're relying on this judgment. So I'm saying, if that was your position at the time, why did you not say you don't have the power to intervene or to interfere? And here is a judgment that tells you that.
Mr. Commissioner, sometimes you have to read the room. Honestly, you have to read the room. We were confronted here by things that were unheard of in my entire career in the municipality. Even the example that I gave earlier on about intervention by the municipal manager in 2017, it was not at this level. It was at the level where there was no disciplinary tribunal constituted. It was just a report from the department, and she stopped it even at that level and then instructed me to do a new directive on how these things must be handled. This one was just unique. This was unique. And the situation that we were faced with, quite honestly, we were not going to go up against Mashaz. Heads of departments.
I think people who abuse power are enabled by people below them who act defeated, and they just say, oh, well, I've read the room, it looks like, I know this is unlawful, but I'm going to go along because what can I do?
In a way, you are correct. I believe also in that principle that in order for evil to prevail, it only takes good men to sit and do nothing. I believe in that principle. The system in the institution is such that if indeed you have that view, you have to then either submit a grievance to the mayor, and I can tell you now, grievances that are submitted to politicians honestly go nowhere. Alternatively, I think it's section 64. Again, section 64 talks about appeals, but they are mostly meant for your residents if they've got issues with regards to municipal decisions. Now, even if you were to do that, again, it goes back to submission to the mayor, and the system, it's especially at municipal manager level. Yeah, I agree with you on the principle, but at municipal manager level, it's not that easy.
Is it a function, maybe I may ask, what is it a function of? Is it that there are no, that there isn't enough safeguards in the system that, and as a result, the kind of conduct that you're complaining about, including at city manager level, it has a fertile environment to function successfully? And what should be done? What is it that is missing in the system, in the governance system, in the regulatory system, that you would say permits this kind of behavior, if any?
Firstly, Madam Commissioner, I need to state that for me, honestly, this was a first. I mean, this was in June 2023. I'd been a manager in HR in Ekoruleni since August 2003. So in that 20 years, this had never happened. It has never happened. I've never seen such overreach by a municipal manager ever before. And as much as I've had to consult, brief, and indeed take guidance and direction from municipal managers over the years, and I'm talking about close to 6 municipal managers, inclusive of this municipal manager. She has never done this before, And I don't know whether indeed she did it post this, or this was just an isolated incident, but you just get thrown, because indeed the system does not envisage that such would happen. You do not have anything in the system that provides you as I can say divisional heads, part of, let's say, senior management, with HODs and the municipal manager in top management, so be senior management. But you don't have anything that actually provides for this, because this was unique. This was unique, honestly. Besides submitting a grievance, which, yes, indeed, was open to me as an official, but beyond that, there is nothing really to do that could have been done.
So it's not...
The system was not actually designed to anticipate this type of overreach.
Am I correct to understand you to be saying it's not so much a shortcoming of the system and the regulatory governance tools that are in place? It is more a personal, it's more a personal thing, the person and whatever informed their conduct. Am I correct to summarize you that way?
That's on point.
Thank you.
Thank you, Commissioner. Mr. Ngiza, perhaps then to locate the totality of your evidence under this heading thus far, you've explained to the Commission that Brigadier Mkhwanazi was suspended in February of 2023, correct?
Yes.
And that suspension was uplifted after intervention from Ms. Xhasheka and the city manager. Is that correct?
I think it should be the other way around. After intervention by Mashazi.
There we go. The next event is upon the upliftment of the brigadier's suspension and his resumption of duty in May of 2023. Chief Mapieye made an attempt to move him out of his ordinary station. Is that correct?
Yes.
And that attempt to keep him out of his ordinary station in order to protect the integrity of the investigation was also blocked through intervention.
Yes.
The intervention of who?
Well, the letter came from Xhasheka, but I believe that it was per instruction by Mashazi.
Thank you. And you've now testified that in June of 2023, an attempt was made to serve the charge sheet upon the then Brigadier Kwanazi, and that the service of that charge sheet was blocked. Is that correct?
Yes.
And please remind the Commission at whose intervention that blockage was alleged to have occurred.
Mashazi and Xhasheka. Quite honestly, my sense is that it's Mashazi instruction to Xhasheka. But at the center of it would have been Mashazi, and Xhasheka just follows, because she's afraid of being shouted at.
Thank you, Mr. Ngiza. If I could then ask you to turn to paragraph 68 of your witness statement, please. 68, we're now on page 23.
Yes.
Yes, you've indicated the blockage of serving the charge sheet. Please then tell the Commission what steps you took immediately thereafter.
Well, I called Mapieye after I had instructed Sidzamba to also record this blockage on email. I also called Mapieye, indicated that this is the situation, that the charge sheet has not been served. Well, he also just took note and said, it's fine, let's see what we can do.
Please continue with reference to paragraph 69.
And then on the next day, Chief Mapieye then called me. Remember, we had discussed the issue on the previous day. Then the next day he called me to say that he was called by Mashazi to her office and instructed to bring the docket. Then, when he got there, he was told that he must go and see Advocate Kemi Behari, who was the head of Corporate Legal Services. And then when he had an engagement with Kemi, gave Kemi the docket, perused it, and then he took a view that there was no case against Mkhwanazi. I must also pause to note that indeed the docket did not have the charge sheet that was perused. The docket that was perused was the investigation report with its annexures, but it did not have the charge sheet from the lawyers at that time.
But the documents, the investigation report would have told him.
Yes, the merits.
Both the city manager, if she wanted to read it, but Advocate Behari, who is given the docket, the report would have told him what are the allegations.
Exactly.
Thank you.
So it cannot be an answer to say Advocate Behari did not have the charge sheet, because if you want to know whether or not there's a case against Brigadier Mkhwanazi, you ask for the charge sheet. You can't say because it's not there, I'm going to form a view that there is no case.
Well, that is what is expected of a reasonable process. I'm not going to say a reasonable person. A reasonable process would dictate that indeed you must have the fullness of the situation in order for you to make an informed decision. You know, I honestly don't understand how this transpired, because you have a situation where the previous day a charge sheet is blocked from being served. So, for all intents and purposes, they knew that the charge sheet was there. There is a charge sheet. But for some reason, when there's an engagement with my PA, the engagement is limited to an investigation report, and the concentration is to say that this investigation report does not have evidentiary material that to sustain the holding of a disciplinary tribunal. And I can tell you now, commissioners, this is discipline management. This is not a trial in court. This is about discipline. Quite honestly, we have approved disciplinary cases on far less than what is contained in that bundle, or in that docket, because this is about affording an opportunity to an employee to come and explain himself to the employer about his conduct or his alleged conduct. So the test is not as strenuous. But nonetheless, you have a situation here where a decision is taken to say, no, there is no case here. There is no case here. And this version, or this thing that is given to my PA gets given to me at a later stage as well.
Did Advocate Bihari speak to you or to anyone from your section who have been involved with this matter when he considered the docket and he got to the conclusion that there is no case? Was there ever any engagement?
Not at this stage.
Not at this stage. And before this, had he been involved with you or anyone in your department relating to this matter?
Nope. Before
this point?
Before the 21st of June, there has never been a Kemi Behari, Advocate Kemi Behari, anywhere in the picture, especially on this matter. When I had a conversation with Chief Mapie, I was quite taken aback to say, but who can I guy? Where does he come in? The delegations matrix at that point did not even involve him whatsoever. There was nothing that actually spoke to litigation. At this point, there is not even litigation. This is a disciplinary hearing. That's all. So there was no need for me to have a discussion with Advocate Behari. And for that matter, there was not even a need for me to have a discussion with Klashega or Mashaz. There was simply no need.
And before this intervention, or now the involvement of Advocate Bihari as, I think, head of legal, the legal person,
yes.
Had the legal department gotten ever involved in disciplinary, other than litigating, when it's now at litigation, but at the stage at which the employee relations department is managing disciplinary processes internally? Is there a role for the legal department?
The legal department would get involved in discipline management matters that are at the senior management level. The disciplinary regulations, the heads of departments, they got involved. I know that Advocate Kemi Behari was involved at some point when we were dealing with the COO. At some point we were dealing with an HOD. He got involved with those particular matters. Even then got involved because of his deployment by the city manager. But in the actual discipline management matrix, there was no need at that point for the legal department. There's a number of cases, even at HOD level, that had been processed. Advocate Behari was HOD corporate legal services from the 1st of March 2023. So historically, we would not have the involvement of the corporate legal services department unless there is a particular legal issue that requires their involvement, but only at that level.
And Brigadier Mkhwanazi's position was not that senior management level you are speaking to.
No, it wasn't.
Thank you. Thank you, Ms. Mkhwanazi.
Thank you, Commissioner. Mr. Ngiza, you say at the end of paragraph 69 of your statement, you say there that Chief Mapieye was subsequently instructed to withdraw the internal investigation into Brigadier Mkhwanazi. In the following paragraph, you discuss the effect of that withdrawal. And please detail that to the Commission.
Yes, Commissioners, the so-called withdrawal letter of the 22nd of June 2023, firstly, Mapieye was functus officio. His role ends at a particular point. His authority ends at a particular point. And that point is reflected in in his letter that I approved on the 12th of April 2023. Beyond that, he has no authority over the matter. I am seized with the matter. So the letter of the 22nd of June was intended to undo something that had already, transpired. In essence, firstly, the letter says he's withdrawing an internal investigation. On the 22nd of June, there is no internal investigation. There is no internal investigation. The internal investigation was concluded in March 2023. It was brought to Xolani Ngqiza in April 2023. He had taken a decision on what then must happen going forward. There is no internal investigation. We have passed that stage. By the time the letter of the 22nd of June is issued, that letter for me had no force of law because it spoke to a process that does not exist anymore.
Is that not a form over substance argument? Because if the instruction was that the charge sheet should not be served and the investigation should be withdrawn, what is the substance of those two instructions taken together?
Okay. The instruction to not serve the charge sheet, firstly, at that point was not in writing. And quite honestly, as much as I had spoken to Mapieye for an intervention, we always said this thing with Norman, this thing can be resolved at some point. But that for me, it's an instruction on a different process, even though the processes are linked in the sense that start by investigation and then goes to Disciplinary Tribunal. But you can't say we are taking a view that the internal investigation be withdrawn when there is no internal investigation. I think that is the point that I'm trying to make. There was no internal investigation at that point.
In his evidence, and maybe in fairness to him, we should tell you what it is that he said, how he explains that. I don't have the transcript in front of me, but I think this can be summarized this way. His explanation is that he was being, subversive. He understood that the investigation is complete. It was his way of trying to keep the disciplinary process alive instead of killing it completely. So he chose this wording deliberately, knowing that he couldn't withdraw a complete investigation, and yet there's no record that he's withdrawn the disciplinary action itself. I think that's a sum of his explanation.
I understand it.
Thank you, Commissioner. Mr. Ngiza, in the following paragraph 71, you set out in your own words what you say was the effect of stopping the charge sheet, viewed against the effect of withdrawing the internal investigation. Could you please set out your views there?
Yeah, my view is that indeed like Commissioner Kumalo had raised it, that substantively it meant that the disciplinary proceeding could not proceed, because without the serving of the charge sheet, you can't have a hearing. So for as long as the charge sheet was not served, the disciplinary proceedings could not proceed at all, even though there was no official written withdrawal of the disciplinary proceedings per se, and technically it would mean the attorneys and the advocate were still on brief because there was no withdrawal of that particular instruction that they should prosecute the matter as it stood.
You are more. I asked the question because of your experience in the space as an employee relations person. Is it not a form of misconduct to intervene in this way without a rational basis for it?
It is. Straight up, it is.
And you would say, where does it belong in your code? Either in your code of discipline, which lists forms of misconduct, or as a matter of common law or law of general application? I ask because it bothers one that you would have this kind of conduct, which is highly suspect, if one, at best. It's highly suspect, and yet there's no consequence for it. And it has serious implications because it has someone who is accused of serious misconduct, very serious misconduct, who goes unpunished because those who have power by virtue of office, they use it to circumvent lawful processes. They're basically the law, collective agreement. It's a form of subordinate legislation, and they subvert the law for no rational basis. Surely it can be, that's the end of it, and there's no consequence for such people.
You are correct, Madam Commissioner. It can be the end of it, and it shouldn't be the end of it. And perhaps critical in your analysis is the abuse of power by people that are in authority. This is a classical demonstration of such. You have people that are in authority, they step in and they cause something like this to happen. But not only did they cause something like this to happen, other things flowed from it. You have a person who was supposed to be disciplined and potentially be dismissed in June. In December, that person gets promoted. By who? By the very same people that stopped the discipline. The very same people that stopped the discipline. There's another issue that I'll be raising later on in terms of the effect of this stoppage. And you could see that indeed what was at play here is a serious, and as by deviation would be
a mild way.
It's to say that there was a deviation from processes and procedures would be, it's kindergarten language. And I can't find the right language to actually describe
blatant
this.
disregard of the blah, blah, blah.
Blatant abuse of power in disregard of the law.
If the evidence leader would allow me,
You have the chairperson's permission to speak freely.
Freely, okay. You have a situation here to show. I just want to show how this thing actually played out. The disciplinary charge is stopped on the 20th of June. 2 weeks down the line, a report gets served that seeks to give Advocate Kemi Beari and Linda Tlashega a 600,000 rand increase. And that report does not provide any basis why such increases must be effected. These two people are appointed on the 1st of March 2023. They are still under probation. 4 months after their appointments, a report gets generated seeking to provide them with massive increases. And nothing has actually happened in the intervening period between March and July in terms of municipal processes. What is in that report speaks exactly to what they had in March, but in July, that is used to say these people must get these massive increases. I can only suggest or opine, but thank you. You are aligning yourselves to the instruction. You've aligned yourselves to the instruction. You've aligned yourselves to what I want as the city manager. My person is not to be touched, and you've ensured that my person is not touched. Here is an increase.
Unless, of course, there's evidence that on their appointment, the terms of their appointment was that at the end of the probation period, they would get increases. Yeah. I'm not saying that's what happened. I'm saying maybe it is some way.
There is no such. Doesn't exist in local government.
You're the expert. I will not.
There is a regulatory framework that deals with what is called the upper limits for the total remuneration packages of municipal managers and managers directly accountable to municipal managers. That thing is determined by the Minister of Cocta. There is a framework on how such salaries are to be determined, how even cost of living adjustments are to be effected. But for the first time in the municipality, again, immediately after having protected Mkwanazi, increases were effected. So for me, it's yeah.
I'm going to test your opinion or your view again. You see, Parliament will say to people like you, we've done our job, we've passed the Protected Disclosures Act. Everything you've just said now, you could have made a protected disclosure and you would be protected from an occupational detriment. And the law is there for officials like you to use it. Why did you not use it?
I was suspended in September and dismissed the next year without even a hearing.
2 months later.
Yes.
But you accept that the law is there.
The law is there. And I've utilized the law, I've dealt with the issues that pertain to that law.
Between May and August, a protected disclosure could have been made.
I take the point.
Thank you.
Well, maybe let me add, and it's on the back of that you could have taken steps. On a quick look, the abuse of entrusted power is defined as corruption. So you could have gone to the police with these things that don't make sense to you for the police to investigate. So there may have been an avenue that was not explored. Okay.
Well, there's things that I suffered, commissioners.
Yes.
There's things that I've suffered personally, even during the period that we are talking about. You know, there's things that I suffered.
Thank you. It's please do not understand us to trivialize the circumstances that you found yourself, not just you, in fact, even the witnesses that preceded you, to trivialize them and to be criticizing that you didn't do anything. It is simply to explore whether you realize or recognize that there may have been things that you could have done, but you didn't do because of the circumstances.
I think that we will perhaps, in the fullness of my testimony, then perhaps also revert back to an analysis of what could have been done, or, what did I miss out, so that indeed if commissioners were to get a full sense of the circumstances that one was confronted with, then there will be a better appreciation of some lack or in terms of processes that one could have been able to put in place.
And remember, we have the benefit of hindsight, which is unfair to you, but take it in that spirit.
Thank you, sir.
Thank you, Commissioners. Mr. Ngiza, we are at paragraph 72. If I could take you back to paragraph 72 of your witness statement on page 23. In the last two remaining paragraphs of this subheading, you set out your frustrations following the inability to serve the charge sheet on Brigadier Mkhwanazi. Please set those out for the Commission in summary of this topic.
Thank you, Counsel. Of course, the legal team or the prosecution team that was appointed were very frustrated. They raised issues to say, but how can this be left unattended? Remember, they had consulted with witnesses. They had even a much more fuller appreciation of what was at stake, because they not only had the documents, but they had a human view, a human touch on the issues. So I engaged with the advocate that was appointed, and of course, he indicated his frustrations. I also indicated my own frustrations back to him, because the matter was scheduled to sit on the 3rd of July, in line with the 3 months that one was chasing, that within the 3 months the matter must commence. So there was that particular frustration that was expressed by all involved, let alone the frustration in the department in terms of senior management of the department. At a later date, I was updated that not only did the charge sheet not go out, but the external lawyers were also not paid. Of course, this was frustrating, and indeed, we were incapable to proceed with the disciplinary hearing at all.
And can I ask you to read that last sentence of paragraph 73 into the record?
Despite engaging the most senior official at EMPD, which would be the Chief of Police, my superior, which would be the HOD-HR, and the City Manager, brought any inquiry into Brigadier Mkhwanazi to a halt.
Thank you. And Mr. Ngiza, do you know if these charges against Brigadier Mkhwanazi were at any point ever served on him, or an attempt was made to revive or resuscitate this process? I ask the question mindful of the fact that you left in March 2024. At that point of departure, were you ever aware of an attempt to revive or to attempt to reserve the charges on the Brigadier?
I need to correct the point about when did I leave. I was suspended effectively on the 7th of September 2023, and I was rendered a persona non grata. There was a directive issued that not even a single person was to speak to me from the municipality, let alone from my division. I was even actually, I even raised an issue to say, I was told that I must not even go to municipal offices even to pay for my rates and taxes. So that ordeal didn't just happen in March 2024. But coming back to your question, nothing has ever happened to Brigadier Mkhwanazi. Nothing.
That
No-
you were aware of, up to and including your point of termination?
Nothing.
Thank you.
Instead of something happening, he got promoted. Something happened. Yeah, I'm wrong. Something did happen to Brigadier Mkhwanazi. He became a deputy commissioner.
Do you think your suspension had anything to do with the charges, the suspension of Mkhwanazi, the charge sheet, and all of those, or it was unrelated?
Can I hold on a bit? Let's go into the next. I need to get the fullness of what happened, Commissioner. I need to get the fullness of what happened and how these things actually unfolded.
Okay, you can stop me as well if it belongs in what you're going to be saying later, but I'm asking the question on the back of what the last thing you said, which is instead he got promoted. Now, we've had evidence, I think from Chief Mapie, about an interview, a selection process, application, shortlisting, and something else that ended up prematurely without that ended prematurely because the step that was supposed to complete that process was not done, but the next thing he was appointed and he got his colors. Do you know anything of? Yeah, I struggle to remember the name of that thing.
His rank.
His rank, but didn't learn to wear it properly. Were you involved with that selection process? Do you know anything about it?
Madam Commissioner, I was not involved with the selection process, but I do know about it. And again, this is another demonstration of how disregard, to use the chairperson's language, disregard for policies and procedures has been a norm of late in the municipality. Firstly, and this is from my understanding in terms of even my engagements, even post my suspension, because even though there was this directive, I do get engaged by people on a number of things. The selection panel that was used, I would criticize it. This was a position of a divisional head level, very senior, in the police environment, which is a very specialized environment, specialized in its functionality, specialized in its regulation. Then you have a selection panel where it is the chief of police, of course, who is an expert in policing. It is the HOD-HR, who knows nothing about policing, with all due respect to herself. It is the HOD, Sports, Recreation, Arts and Culture. Nothing about policing. Now, the problem with how recruitment and selection happens in our environment, and this is a criticism that I even actually made in a matter where we were a respondent in an unfair labor practice dispute relating to promotion. And the criticism that I made, and fortunately for the municipality, we won using that criticism, is that you have a situation where the actual suitability of a candidate for appointment is premised on an aggregation of the scores. you aggregate the scores of the 3 panelists. And then, having aggregated the scores of the 3 panelists, the candidate that has got the highest score gets to be the one that is recommended. Now, in a situation like this one, the 2 people that are not experts on policing, I have not seen the scores, but I can tell you now, would have scored Mkhwanazi better than the person who's an expert on policing. Because there is a predetermined notion that he will be promoted, come hell or high water. That is the first point of call, before even getting to the other steps. How this thing was structured, it had a predetermined outcome. So whatever the chief of police scores do not be used as a benchmark of how the person is answered. If the chief of police scores the candidate 2 and the other panelists score the candidate 4, aggregate the scores, that candidate becomes the highest scored person, even though the expert said these answers are not correct.
Is that a fair criticism, though? What options were there within the municipality to constitute the panel differently, taking into account what you're saying about experience, that the people who know anything about the environment should not have been there? I think that's the nub of what you're saying, that you've got 2 people who know nothing about policing. What would have been the options available to the person constituting that panel, apart from the chief, who is an obvious choice? What options would there have been for the other 2?
The options that would be for the other 2 are informed by what has happened with previous appointments at that level in the EMPD. All right? Because this was not the first time that the EMPD was having an appointment of a deputy chief of police. It was not the first time. So in previous instances, you would have the chief of police and the head of department disaster and emergency management services. The head of department disaster and emergency management services is the closest, because that person is involved in the uniformed service. In the uniform service, and indeed there are those overlapping functions that actually are involving both EMPD and DEMS. We call them DEMS, Disaster and Emergency Management Services. So the precedent in the municipality has always been that DEMS HOD, even if it's an acting HOD of DEMS, would sit with the chief of police.
All right.
That has been the precedent.
Okay.
But I can tell you now, there's been a number of instances where when you're having a divisional head position, specific individuals are then drawn to be the panel, because a particular outcome will then be determined. Specific individuals that are consistent in the panels for divisional head positions.
I interrupted you. You were still explaining what you know about that process that ended prematurely, the selection process, but somehow
Yes.
Brigadier Mkhwanazi was selected.
Thank you, Madam Commissioner.
Please hold that thought. Let me continue the interruption. On the facts that you are aware of, why do you think the city manager was as invested as she was in Brigadier Mkhwanazi? I wanted to also include Ms. Tasheka, but I'm not sure whether I should, because at some stage you said that she said she didn't want to be shouted at and wanted to see the finalization of the DC process without a hearing having taken place. So maybe let me leave her out of the equation for a moment. So why do you think, on the facts that you know, the city manager was as invested as she was in in Brigadier Mkhwanazi?
Thank you, Chair. I think, Chair, there's a point, I think it was I'm not sure it was yesterday or early this morning, when I had to give a view on the proximity claim. And I indicated that when you look at the hierarchical arrangement of the municipality, there shouldn't be a proximity between the two individuals. But nonetheless, that proximity does exist, And perhaps one would have to then investigate what informs this proximity. Because this proximity, in my view, is what then informs the municipal manager's attitude, the municipal manager's conduct when this individual is involved. When this specific individual is involved. There's a number of matters that we've dealt with this municipal manager. A number of matters, including HODs, including other people that were even in her office, directly in her office. But this was unprecedented. And the only thing that one can opine is that it is unprecedented, and it is the type of conduct is informed by things that are extra. Is there extra organizational? There's extramural activities, So there's something that is beyond organizational arrangements that, in my view, exist between Mashazi and Mkhwanazi. That would then inform the proximity claim. That would then inform the conduct of the municipal manager in respect of this individual, protecting the individual, not only protecting the individual, advancing the individual. There's so many things. You have a situation where, and it's just unheard of in the municipal environment. A person gets appointed to a position that is the equivalent of other positions, and there are other people that are occupying those positions. This one comes now, umafikizolo, literally this is the mafikizolo. But then the mafikizolo gets to act and be the supervisor of the people that have got more service, more experience, more qualifications, more this, more that. But this person gets to act. And these ones never get to act at all. For as long as Chief Mapie was on leave, was put on special leave, was suspended, one person acted. Council policy on acting is clear. There must be a rotation of acting. But there's no rotation of acting. This person gets favored above everybody else. And there is no rational basis in terms of the institution, in terms of processes of the institution that I can think of that would put the municipal manager in that position where she has to make sure that this one person enjoys protection, enjoys benefits, enjoys everything. There is nothing institutionally. So then it has to be on a personal level. The allegation against me and Chief Mapie is that we are personal against Julius. I don't know how do I become personal chair. I don't even know the man. I've never seen him outside of uniform. I've never seen him outside of uniform. I've never even met him at a funeral, except for a funeral of an EMPD official, where even then he's in uniform. But I'm personal against him. I don't even know his stays. I don't even know his family. I know nothing about him, except for the fact that he's an employee of the municipality.
Based
But
on
here, clearly there is some personal relationship.
Based on what you know, would you say that Ms. Xasheka's claim that she did not want to be subjected to continued rebuke was the full answer to how she herself conducted herself with regard to Brigadier Mkhwanazi?
My understanding of Ms. Tlasheka and her tenure as the head of department HR, which would have commenced when her predecessor left the institution, I think it was at the end of July 2022, and then Ms. Tlasheka was appointed to act in the position from August 2022 until the 28th of February. She was acting, and then she got appointed from the 1st of March. There is no other rational basis that I can think of that would make her, as an HOD-HR, to act in the manner in which she acted, except for her fear of marshals. Because that is how she has always addressed herself.
That's exactly what I want you to address. On the basis of what you know, do you think that the manner in which she acted was indeed motivated by her fear for Ms. Mashazi?
Nothing else.
Thank you.
Thank you, Chair. It's 4:01.
Let us adjourn and resume at 9:30 tomorrow.
Emapili muna, but to say the